Yo, folks, it is Easter, and we're going to make this a bit Easter-esque while watching some of our favorite judges doing stuff in the courtroom. Also, I'm going to show you how to make a proper Easter pickled herring. Welcome to the show. Yeah, welcome. It is Easter, and although I have plans for tomorrow, I thought, I've done all the family stuff I needed today, and I will meet up with family tomorrow evening. Different parts of family. Hey. But also, there's a bunch of you guys that may not have that luxury. So I thought, hey, let's just go online and see what happens. But first, I will show you. Now, of course, the ingredients for this is not easily available outside of Scandinavia. What I have here is matjes. This is prepared pickled herring. Now, I already drained this somewhat of the fluids. It looks a bit like this. Look, delicious, delicious. Pour it into a bowl. Now, this is good by itself. Many people eat this just by itself. But pour it in a bowl. Then you add some of the things that you like mustard. Mustard is very nice. Very nice. So, a good chunk of mustard. And mix it around. Welcome to Cooking with Nik. Well, it's not as much cooking. Now, be sure to coat the pickled herring, which was again drained, but not completely drained, so it gets. See? Look how nice. Look how nice. And then to have a bit of more spice, peri sauce. Peri sauce. Also very nice. So, and I dropped my fork. Well, add drops for taste, according to your taste. And then scoop it around. Nom. Spicy mustard pickled herring. Now, usually this needs to rest for a while. So I'm going to put it right over here for a bit. Right over there for a bit. While we wait for it's going to be so nice when it draws in all of the flavors and everything. And while we do that, of course, it is Easter. Now, this is not the ordinary Easter beer. We have Easter beer over here. Now, those are usually a bit darker, but I chose a completely liquid bread. That's more my taste. All right, let's let that rest for a bit. Let's see who's here. Washbar, happy Easter, everyone. Happy Easter. Nicola, happy Easter, happy Easter. K-Dubs, my father used to eat this a lot. Yeah. Oh, look at this, look at this. Thank you so much. Pinning that. Santa Claus, Easter Bunny. Oh. Oh no, JK, your kid got called into work today. That's not nice. That's not nice. Hello, Danny. Hello, LMP, Becky, Gwendolyn. Hello, folks. And hello, you folks over at Rumble as well. Now, where were we? What? It is Easter. Now, you haven't seen this in quite some, because to make it more Eastery, of course, we need the Easter hat. Of course, we have to have the Easter hat. Where did you put your wing? There. All hail the chicken pope. Oh, very festive. Yes. Because we all know when the 2000 years ago, when everybody, well, we have to commemorate the memory of the sacrifice and everything. And up here in the cold north, somebody said chickens. And somebody said egg. And then somebody said pickled herring, which the rest of them, but you have pickled herring for midsummer, you have pickled herring for Christmas, and our guys just said pickled herring. So yeah, Easter up here, we don't have the Easter bunny, we chicken, egg, and pickled herring. So while we let the pickled herring rest for a bit, we have poured ourselves a drink of choice, and I'm borrowing. Oh, hold on. That's borrowing from Dali Talks, who live streams Monday through Friday, every day, so we can have some fun at this. Let's see here. Should I put myself up here in the corner, or just here to the side? Maybe like this, like that. That looks fine. All right. Also, a tradition over here once we eat pickled herring, because pickled herring, I mean, it's very strong flavored, it's very acidic, and it's very potent. Usually we have a schnapps. So, where's that? Do I have any schnapps left here somewhere? Well, I have a little bit Pors schnapps from Aalborg. So I have a little bit left. All right. So on what we are going to watch today is we have Judge Simpson, we have Judge Fleischer, and I do believe we have Judge Middleton as well. So it's casual watching, watching cases go by, watching how these judges behave themselves, and just have a sweet time together. If herring is pickled, it makes it too drunk to run for it. Yes, today is not Santa Claus, it is Chicken Pope. All right. Let's see what happened here.
On payment of rent case, what's the plaintiff's claim including cost?
The amount including cost is $6,158.00. It's January through March with court costs.
All right. And Ms. Cheatham, we've got a picture now, and if you can unmute.
Okay.
Okay, there you go. All right. How are you intending on trying to get this paid?
Okay, so this is the deal. I've spoken with Ms. Shifter because this has been kind of a complicated process. It was a possession case. I don't know if you remember. I was in here maybe a few weeks ago. It was initially a foreclosure, and then I had signed a lease. And speaking with Ms. Shifter, is to vacate, and there was some discussion about possibly avoiding a judgment. I have reached out. I have some help coming my way through a place called Here to Help organization. They help people that were incarcerated with funding for new places. Basically, my intent is to vacate. It was waiting for my inheritance to come through because the thing, I have the money to pay the back rent. And if I do that, then I don't have money to move. And I don't think that they want me to maintain or remain in the lease is the thing. So they just want the property to vacate.
Okay. So if I adjourn this out a couple of weeks, you guys think you can get that all solved, or?
I think so, because my intentions are to be later 15th. It'll probably be sooner than that, but
Judge?
Counsel?
Thank you. If nothing else, I'd like to make a record. Your Honor, you may or may not recall, we filed this case late last year as a termination subsequent to the expiration of the redemption rights. We did a termination. You dismissed the case because my client executed a lease because Ms. Cheatham advised that she wanted to stay in the house. She tendered a payment, which subsequently was reversed as NSF charges. The court advised the parties that this had to come in another manner. So we filed a non-payment case. Respectfully, this story about moving out has been going on since, I don't know, late quarter of 2025. So I frankly find that this explanation is intellectually just disingenuous, Your Honor. So if Ms. Cheatham was going to move, I mean.
Yeah, I actually remember this case from late last year. And it seemed like, everybody was happy, But as it seems, Ms. Cheatham just used this grace from Judge Simpson to just stay longer and still not pay rent.
We've been asking since late last year when the termination was filed. And then when the payment was made, when the lease was executed and was reversed, it was clear that she wasn't going to stay there. So, and Ms. Shifter has not advised me, or my client has not advised me of any agreement whatsoever. None. Zero. That's why we're back here, Judge. So,
Ms. Shifter, help me. Who is that with reference to these parties?
She's a representative of the plaintiff. She was here. We came in an in-person hearing that resulted in a default judgment. I can't remember the exact day. If it's of any importance to you, I can find it. But we got a default judgment. Ms. Cheatham filed a motion to set aside the default. You granted that.
No, I recall.
Okay, I'm sorry. I don't need to go.
No, it's okay. It's okay. No, I recall because it was certainly an unusual circumstance.
My client made an error. no good. This is classic. No good deed goes unpunished. There was a lease executed. Ms. Cheatham advised that she wanted to stay in the property. It was her family property. My client did that. They signed the lease. Guess what? The payment was reversed, but the court felt, well, counsel, your client has a landlord-tenant relationship now. Well, here we are.
Yep.
January's not been paid. February's not been paid. March has not been paid. And now we're being told, oh, we need time to move.
Well, here's the thing. It's now filed as a non-payment of rent type of case. If the parties can't work it out, but she would be entitled to an adjournment of the proceedings. How much is monthly rent on this?
Monthly rent is $1,900.00, Judge.
1,900?
Yes, 1,900.
May I respond to Mr. Is it Spaniolo? I spoke with Ms. Shifter, I believe, on the phone. It was I think it was the Friday before last. And I advised her that I was trying to get in contact with my lawyer to get a definitive timeline of when my inheritance might be coming through. But that's neither here nor there. My intention in the first place was to stay in the house, and unfortunate things happened. And I don't know if you remember, it's neither here nor there. The money, I had it, and then something happened and it was gone. So at that
All
point,
right. Here's what I'm going to do. I'm going to reserve the issue of escrow because I can't order it at this. She would be entitled to an adjournment in any event, this being a non-payment of rent case. I don't have a week out. I do have 2 weeks out. So I will adjourn this to April 10th.
Yeah, this is the risk you're running as a landlord, that you get tenants like this that uses the system to live for free. And I recall another case where a lawyer did and didn't represent two people who rented quite a large compound from people who, that was their retirement. That was their retirement, was to rent that out for quite a substantial amount of money per month so that they could retire. And it started a year and a half ago. And the tenants never paid rent. They just drew it out. And sadly, about a month ago, there was the last hearing where the attorney, representing and not representing these two squatters, just took off with $22,000 that was supposed to go to the landlords. And the landlords were forced into bankruptcy. So they played it for a year and a half without paying rent, to the extent that the owners of the compound had to file for bankruptcy. It's infuriating. And that attorney, those two squatters should be on the hook for all of it. I hope, though, that family, the landlord family, has the opportunity to sue them if there is money to be collected. But that's the dangers of being a landlord in Michigan. And it's infuriating.
2026 at 2 p.m. That is an in-person hearing. And given everything, I think I'm going to want all the parties.
Understand that. Forgive me, Your Honor. You said April 10th, correct?
Yes, April
Okay.
10th, sir.
At 2 p.m. Thank you, Your Honor.
Thank you.
Have a good day.
You do, sir.
thank you.
Babu Bandapati, versus Melody Sittenhelm.
Good morning. Hello?
Who is that? Check in.
Hello? I'm online.
State your name, sir.
This is Babu Bandapati.
Okay. And we do not have We do not have the defendant to pay for a second mailing. No, no second mailing by the court. All right. Why do we have? All right. Okay, sir.
Yes.
I don't have the defendant here. You did not pay for a second service, so I can't take a default. The only thing that I can do is adjourn this out to my next hearing, noting that the defendant hasn't appeared at this time.
Okay, just a side note on this one. I think the defendant needs help. Currently, she was on Section 8, just a backstory here. And basically they cut her payment and she has health issues currently and she doesn't know where to go. She's thinking possibly hospice. Not so. She's really kind of at a situation right now, crossroad, where she can't stay in the house because the power is going to be cut off and everything for non-payment, and I'm concerned about her health right now.
Got it. I hear you. Okay. Not sure there's much we can do at this point. All right. I'll adjourn it out to April 10th, 2026 at 2 p.m.
Yes.
At 2 p.m.
Okay.
And maybe she can get somebody repetitive or somehow or another communicate with the court regarding where she is on this.
Fair
Okay.
enough. Fair enough. Thank you, sir.
Okay. Thank you, sir.
Yeah.
Joseph Getz
Hey, Dolly.
versus Joshua West.
Borrowing your
Morning, Your
borrowing
Honor.
stream here.
Okay. Mr. West, I'd appreciate you not smoking.
Yeah, no, I'm not.
Okay. All right. Mr. Getz,
Yes, Your
what
Honor.
is what is your claim in this case?
So he hasn't been paying rent for the last 2 months. We're approaching a third month without him paying rent. I tried to serve a notice to vacate on the first month and I didn't use the right paperwork. So I served a 7-day notice to quit.
Okay. So, sir, how much does he owe?
At this current moment, $1,400.
All right. Then you've got costs, it looks like here, of about 87. All right. Sir, Mr. West,
Yeah.
how are you intending on getting this paid?
Well, what happened was when I moved here, I didn't have any money. And I've known this guy since like first grade. He told me it was cool. And I got 2 jobs and I started paying the rent. And the rent there was never any lease signed or anything. I never got, but the deal was that when I started working, it was like, I'll give you the money when I get paid. And in January, I paid him on the 23rd. And then in February, he got all drunk and started freaking out and told me he was going to throw all my stuff out and started putting my stuff in boxes and throwing my food away. That's why I didn't pay the rent.
Oh.
And I would have moved out if I had anywhere else to go. But
All right.
I don't have anywhere else to go. So
This is a non-payment case, so do you have the money to pay?
No, not now. I don't.
Idiot. So you had the rent money, decided not to pay rent because he was being an asshole, according to you, and then you spent the money. That's not a clever way to do this.
Yeah. I moved in here and this guy told me he was on felony probation and he wasn't drinking. And then he's drunk every day going crazy. And I ended up getting fired because I didn't sleep for a week dealing with this. Like, it wasn't like I just didn't pay the rent. Like, I'm trying to get it together
All right,
and get out of here.
Second service wasn't paid for. What I'm going to suggest.
I don't know what that means. I don't know what that means.
There's not a second service by the court, which means I can't take a default or do anything today. I'm going to adjourn this out. Mr. West, if you think that you need an attorney, and for that matter, Mr. Guest, if you think you need an attorney, that'd be your opportunity to hire an attorney. We'll adjourn.
Let's see. So, behind the guy on top left, what is that tree? That is the tree of life, I believe, that he has behind him. It's sometimes used in the old Aesir as the Yggdrasil, but I believe that is the tree of life, which is representative of the womb, between the baby and the thing that goes on in there with the umbilical cord, and the branches are tree of life.
This out to February to April 10th, 2026 at 2 p.m. That's an in-person hearing. I'll need you both down here at the courthouse. All right.
You said April 10th?
Mr. West, April 10th, 2 p.m. Mr. West,
Okay.
In the interim, what I'd suggest you do is accumulate what funds you can when you come down, because I think Mr. Getz is probably correct. Another month is going to click in by the time you get back here. And so there's going to need to at least be a payment while you guys try to work this out. All right?
I would pay it if I had the money. I don't have the money. It's not that I wouldn't pay it. I've been trying to find a job.
I hear you. What I'm indicating, though, is that you said you had jobs.
Not anymore. Not anymore. All my
because you got fired.
Yeah.
Okay. Well. Okay. So we'll see you guys down here April 10th, 2 p.m.
Thank you, Your Honor.
Okay.
All right.
Do I have to do anything else right now, or
figure it out?
Well, if you want to hire an attorney, you can, or if you want to seek assistance, you can call the numbers that were on the slideshow at the very beginning. You can call Hawk. Did you get that number?
No.
All right. You got something? Do you have something to write with?
Hold on one second. I do. Okay.
They are 961-1999. That's area code 734.
734-961-1999.
Yes, sir.
And what was it called again?
It's called HAWC. That's an acronym. It's HAWC. Housing Access for Washtenaw County.
Okay, and you said April 10th at 2 p.m.?
Yes, sir. In person.
Is that just Saline Courthouse, or like to get directions?
You're gonna come to the courthouse I'm at, which is the one by the sheriff's department.
What sheriff's department? In Saline? Or?
No. All right.
I just moved here in October. I'm not from. I don't know.
Okay, no, I got you. I'm just trying to explain it to you.
I'm not trying to give you a hard time,
sir. I'm just trying to tell you how to get here.
Okay.
The address is 4133 Washtenaw Avenue.
Okay.
Okay, and it's right off of US 23.
Okay.
All right. So if you were to just ask or put in your phone the Washtenaw County Sheriff's Department, it'll show you this location. We're right attached with them.
Okay. Well, if I don't get some money, my phone's gonna get turned off. Can I still show up and do this without my phone?
Oh yeah, you can show up.
Okay.
I was saying use your phone to find the location.
Yeah.
Okay.
This is not a smart fellow.
We'll see everybody April 10th.
Thank you, Your Honor.
Okay, thank you.
Right.
Yeah, neither of these seems to be clever fellows. Now, let's check out Judge Fleischer instead. See what's going on over there, or what went on over there.
Probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. On March 23rd, in Harris County, officer conducted a traffic stop on a motor vehicle with no front license plate and expired registration. The defendant, the driver, admitted to possessing a gram of marijuana and a handgun in the glove compartment. The handgun was found in a holster and around in the chamber. Officers found a gram of marijuana in the glove compartment under the handgun.
Mr. Fuentes, I'm going to find that there's probable cause to go forward with your case. So he's the driver?
Yes, sir.
Do you see have a license to drive?
I'm running it right now.
Please. As a condition of your bond, while this case is open, you are not allowed to be in possession of any weapons. If I find that you have a weapon, I will put you in jail. No more PR bonds for you. This is not a revolving door. Do you understand me?
He does. It's up.
Okay. How old are you, sir?
21.
Okay. How do you support yourself?
I'm a mechanic.
We're going to reset your case to give you time to hire a lawyer. When I have you go to Victoria, sign and reset, we will have you take a seat in the jury box. We'll get your bond conditions. Do not pick up any new cases. Do you understand? All right, come on. No weapons.
Yes, sir.
I like his jacket.
All right, sir. Bottom of 14. Marvin. Mark, that's for you. Come on up. Thank you.
Hey, yeah, Judge Fleischer seems to have restarted his streams. Now, since the people complaining were the attorneys, because and some of the others, if I recall correctly, so now you only get Judge Fleischer. So we can't see the attorneys and cops making fool of themselves. Because if I remember correctly, they complained that they were shown on stream. So it did have a pause for a number of months. We started streaming again the day of the primary. Oh, Judge Boyd lost her primary? Oh, that's interesting. That's interesting. I mean, she's been a judge forever. Interesting.
Mr. American, you're charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. If you're in the box, don't talk, please.
On March 22nd, 2026, in Harris County, Texas.
Hey. Way too close.
Officer was dispatched to an assault. Defendant is complainant's neighbor. Complainant was observed to have a swollen right eye, a cut on his nose, and scratches on his back. Officer was provided a video of the assault. Complainant was sitting down, talking to two other individuals when defendants walked towards him and started hitting him multiple times. Co-defendant grabbed him and threw him on the ground. Defendant hit him in the jaw multiple times and dragged him to the front of the apartment complex while co-defendant kicked him.
Is that it?
Yes, Your Honor.
Okay. Do you know if alcohol or anything played a factor in this?
It's not clear to me, Your Honor, if there was alcohol involved in this incident.
Right, Mr. Jingles is here, and you guys have sponsored with some treats. So I got Mr. Jingle some treats. Meat sticks. Huh? Look at that. Nom 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 nom. Nom 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 nom. Oh. You oh. So he's so happy. Look at that. And that. And you guys sponsored that. Thank you. All right. Let's get back to the show.
Mr. American, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with the complaining witness in this case or the co-defendant in this case. If you violate these conditions, I will order your arrest, put you in jail, no more PR bonds for you. If you are not in this country with permission and you go to jail for any amount of time more than what you did last time, it's a very good possibility they put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over, and then you get shipped off to immigration. Do you understand?
Ow. Okay.
I don't understand everything.
If I put you in jail and immigration finds you and you're not in this country with permission, they may put a detainer on you. Do you understand?
Yes.
Don't violate these conditions. Don't endanger my public. I am not going to warn you again. We are going to reset your case to give you time to hire a lawyer. I will have you sign a reset with Victoria. We will have you take a seat while we get your bond conditions. The bond conditions are no contact with the complaining witness, co-defendant, and no possession of any weapons. You can go ahead and sign the reset. If you can file this case.
Yes, Your Honor.
All right, Judge, the next Spanish arraignment is on page 20. Santos, come on up.
Please. Hi, good morning.
Oh, thank you so much, Annie Rumpier, for a $2 rumble rant. Thank you so much for the treat fund to keep Mr. Jingles happy. Thank you so much. I'll make sure to buy him more treats.
Mr. Santos, is there anything aggravating about this? Is there any alcohol in the car while he's driving? Any prior DWIs?
No priors, Your Honor, no alcohol in the vehicle, but there was a crash. Defendant crashed into the vehicle and the opposite.
Okay, any prior, you said no priors?
Priors, Your Honor.
Mr. Santos, as a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, and you will be randomly tested. If I find that you're consuming, I will revoke your bond and put you in jail. Does he have a license to drive?
We do not have a driver's license on file.
You are not allowed to drive, and that is also a condition of your bond. If I find that you do, then likewise you will go to jail. You will be signing an affidavit with me today promising, Mr. Santos, that you're not going to drive. I don't care what you have to do. If you do not have a Texas driver's license and a liability insurance in your name, do not drive. Do you understand? I'm not going to warn you again. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, I will revoke your bond. For now, I'm going to have you come up here, swear to us that you're not going to drive. We will have you sign a reset and then we'll get you out of here. You will get with Veronica for your bond conditions. Don't use alcohol. I don't care what your excuse is. Do you understand? Okay. Yes, thanks.
Seems to be a person who has had
All right,
multiple
Judge,
chances.
bottom of 16. Murphy.
Mr. Jingles, you got 2 sticks. 2 meat sticks. 2 meat sticks. If I
Miss
give you
Murphy,
more,
you were charged with driving while
Your stomach
intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Does she have a license to drive?
It's not eligible, Your Honor.
You are not allowed to drive.
yeah, for anybody who wanted, oh, give Mr. Jingles enough treats and he will stop booping with claws. No, he won't. No, he won't. He will only get more. He only wants more. But 2 meat sticks at once. Otherwise, he more, and he gets. Yeah, your stomach will become bad. You know that, but you don't care, do you, Mr. Jingles?
Drive. I don't care what you have to do in this life. You want to drive, you need a driver's license, you need liability insurance. If you don't have either, then this is a condition of your bond. I'm ordering you now to obtain a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. Do not use. If you do, I will revoke the bond and put you in jail. Do you understand, man? Do you have the ability to hire a lawyer? Can you file paperwork for the interlock, please, so that I'm sending notice to DPS?
Seems like Judge Fleischer at this hearing gets repeat offenders in front of him, and he's quite tired of them being repeat offenders.
In Austin, so that every police officer in the state knows that you're supposed to drive with an interlock. If they catch you driving a car that doesn't have an interlock, they're going to arrest you. You understand? So do not drive. Deputy Etchigoin is going to give you an application. I need to know everything about you, how much money you have coming in, all sources of income, whether you're married, property you own, cars you have, and then I'll take a look to see whether you qualify. Come on.
Go ahead and sign. All right, Judge, next is top of 18. Ontiveros.
Why don't you be quiet?
Mr. Ontiveros, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. There's a protective order that has been issued in this case, and you need to get to know it. If you do something to violate this protective order, the state can and will file a violation of a protective order against you. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. You understand? If you violate these conditions, likewise, you will go to jail. No more PR bonds. This is not a revolving door. I'm going to have you sign a reset. We're going to get you out of here to hire a lawyer. I'm going to have you take your seat after you sign a reset. We're going to have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. When you come back, please have a lawyer. Come
So no contact, no weapons now?
on. Correct. Yeah.
I can sign. All right, Judge, top of 19, Rivera. All right, and let's see.
I'd like to do probable cause on this one.
Yes, sir.
Mr. Rivera, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You speak English, correct?
Yes, sir. And
On March 7, 2025, complainant stated that she and her ex-boyfriend defendant assaulted her at her apartment located at 555 Sumner Drive in Harris County, Texas. Complainant stated defendant hit her with his open palm on the left side of her face, then punched her in the nose, causing pain. Officers observed defendant's nose to be red and swollen.
Mr. Rivera, I'm going to find that there's probable cause to go forward with your case. He has a prior violation of protective order and parasitic threat. He's also on 2 felony probations now. Any of those the same complaining witness as this one?
I believe they're different complaining witnesses, Your Honor. I'm going to confirm right now.
What did you say?
I believe they're different and it's confirmed. Yes, Your Honor, different complaining witness.
For the VPO as well?
Yes, Your Honor.
Okay, if this is the third one with terroristic threats, make the bond high. Make the bond high. Because he won't stop, apparently.
Mr. Rivera, I'm going to find that there's probable cause to go forward with your case. There's a protective order that has been issued. You need to get to know it. If you violate this protective order, the state can and probably will file a violation of protective order against you. It would probably behoove you to hire a lawyer as soon as possible. You're on 2 probations now. You've picked up a new case. You understand me? As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to test you if I find that you're using alcohol or dope. If you have any contact with this person, I will revoke the bond and put you in jail. I will deem you a public danger, and I'm going to make your bond high. I'm going to protect my community at all costs. Do you understand me, sir?
yes, sir.
Set it
We
up.
are going to reset your case to give you time to hire a lawyer. So you will get with Victoria to sign a reset. You'll get with Veronica for your bond conditions, and then we'll get you out of here.
All right, then page 24. Go ahead and sign this. Ward. This one is very good. Yes. Yes.
Ow. Don't bite me, Mr. Jingles. I have the scent of meat sticks on my hands.
The one thing we ordered you not to do was pick up a new case. Now you stand charged with evading arrest or detention. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
On March 24th, 2026, in Harris County, Texas, officer was dispatched to a suspicious vehicle call. The reporting party stated he observed female subjects driving around the complex, breaking into vehicles. Officer located the vehicle. Officer exited his patrol vehicle and shined a light into defendant's vehicle. The vehicle began to reverse out of the parking spot. Officer gave command to the driver to stop and announced he was the police. Co-defendant was the driver, the defendant was the passenger. Co-defendant sped off to evade out of the complex. While the vehicle was in motion, defendant opened the passenger door, jumped out of the vehicle. Officer gave commands to defendant to stop, but she failed to comply and began to run on foot away from officer's direction. Officer gave chase for approximately 10 feet and defendant was eventually detained.
So
I'm going to need your help.
She started running, and within 3 steps, he has her on the ground. Oh, I want to see it. I want to see the body cam on this one.
Oh, Miss Ward, I'm going to find that there's probable cause to go forward with your case. You are on your third case in a month.
Oh.
Guess what happens now, Miss Ward?
No bond. No bond.
I'm going to revoke your bond and you will be going into custody, ma'am. Do you mind appointing a lawyer, please? Are there any co-defendants in this case?
There's
Co-defendants?
one co-defendant here.
Okay. Is this in the middle?
Bond revoked. Suffer. Yeah, but 3 in a month? Yeah. You're going to jail, miss. You are going to jail. And I saw one. I really want to see that body cam video. Oh. Ow! Mr. Jingles, you need to stop booping with claws. You really need to. I want to. There. What happened?
Hey, so.
Okay. He's back.
Hey, so she had a lawyer. They're supposed to be coming. Yeah, she said she's coming. The lawyer's coming.
Okay. All right, Judge, so the next one, top of 17, Nesbit.
All right, next one. Feisty Mr. Jingles, yeah.
Good morning, Mr. Nesbit. Do you have a lawyer today?
I do. He's
Okay, who is it?
his name's Dustin.
Okay, we'll wait for him to get here then. Okay.
All right. While we wait for that, as you who were here in the beginning, you saw me making pickled herring, which I made with Matthias herring and mustard and peri-peri hot sauce. Nom 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 nom. So now it's been resting for 45 minutes. Usually it's in the cooler for overnight, but I can't stop myself. Cheers. Nom nom nom. Oh, that's nice. And as per tradition, it needs to go down with schnapps. Let's see here. Let's do the Mississippi shot glass. Ow! Mr. Jingles. Don't go on my leg with claws. That hurt. So. Horse schnapps. Because as per tradition, pickled herring at Easter goes down with the schnapps. Cheers. Ooh. I need a welding sleeve for my left arm to be safe from Mr. Jingles' boobs. Yeah, maybe. Whew. On second thought, a whole welding suit. Yeah, maybe. Whew. All right, let's see what happens here.
The next one is page 21, Thompson. Or sorry, Thomas.
Okay.
Okay. How do you support yourself?
I work full time.
Great. What do you do?
I'm a mechanic.
And how much money do you make a month?
I have $30. But I don't mind my finances.
You have to qualify for a court-appointed lawyer. You know what I mean? It's just, if you spend beyond your means, it's on you. But we don't just give out lawyers like it's candy. I don't have an unlimited supply. So, I'm happy to give you more time. Who do you live with? So you don't pay rent?
Yeah.
And do you have any children?
Yeah.
How many is some? Yeah, 4 kids. Are you providing any kind of support for these children?
They live with full time.
Okay. Ed, do you mind giving them an application? We'll give you an application. I need to know everything about you, whether you have any other sources of income, wife, marriage, anything. And then we'll take a look to see whether you qualify.
There's the top of page 3, so give me a point for that one.
I would say, you get the conditions for a magazine. I think I filed, I'll refile it. Okay, thank you.
I don't know yet. I don't know. I gotta handle it first. Okay.
All right, council full reset.
What's that? Oh, $10,000. Sorry, 10,200. Yeah.
Install this or affirm also.
Still here.
Was not information. That's all.
I have no idea what is saying there in the background.
Council full reset. If they conceal the issue, what was that saying? Email day. Okay, out of my school, it'd be, I'm going to see the photo. I mean, all right, stay. I'm distracting you. Yeah. All right, Judge, I have another arraignment when you're ready.
Okay. You can bring them up.
All right, couple 4, Carrie.
Did you say page 4?
Couple 4, Judge, Carrie.
Mr. Carey, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? If you violate these conditions, I will order your arrest. I will put you in jail. No more PR bonds for you. That is not a revolving door. If you pick up another case, if you endanger my city, it's just not going to go well for you. Do you understand me? And I'm not going to warn you again. How old are you, sir? Do you have the ability to hire a lawyer? How do you support yourself? When is the last time you've had a full-time job? Has it been that long? Okay, it's time for you to get a job. A real, legitimate 9-to-5 job. That is something that you need to do. I will give you an application for a court-appointed lawyer, but I'm bringing you back in 2 weeks and I want to see what you have done to get a job. If you've done nothing, it's not going to go well between us.
Good question from Derek here. Does the cops in Texas do a probable cause when they take somebody into custody, or is that left to the judge once they appear at court? I believe Texas, suspicion of a crime is enough to take people into custody, but then the judge has to do the probable cause, in which they present affidavits or testimony if needed. The defendant can object, and with his own lawyer, if he got one at the time, challenge the probable cause. Many times there is no challenge to the probable cause, that they will do a challenge or a motion to dismiss later if there is challenge to do with the probable cause. But probable cause is the judge who determines. Same with warrants in Texas. They have to present the case for a warrant to a judge who then determines, yes, you have probable cause.
You don't get to sit at home and play Xbox all day while everybody else flips the bill for you. No, sir. You need to be productive so that you have this and you stay out of this. Do you understand? 2 weeks. I want to see 30 applications. Come on. Can you file the conditions, please?
Special condition for bond. Apply for work. Apply for jobs. So he has 2 weeks to apply to 30 jobs. All right.
Yeah.
Go ahead and sign for your reason. Judge, I have another one that was off docket.
Okay.
I have the case number when you're ready.
Okay, what is it?
2611996. Amber, come on up.
Let me do this and then I'll help. Yeah. Mr. Hammer, you're charged with theft. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Government restrictions of DIMS, Your Honor. On March 24th, 2026, in Harris County, officer was dispatched to a theft and progress call located at a Target. Upon arrival, officers met the loss prevention officer, who advised that the defendant entered the store. The customer proceeded through multiple aisles, selecting various items and merchandise from the sales floor. The prevention officer maintained continuous observation and watched the defendant conceal the selected merchandise on his person in a manner consistent with shoplifting. The plaintiff further stated that the defendant bypassed all points of sale and exited the store without making any attempt to pay for the concealed merchandise. The total value of the stolen merchandise was $203.99.
Okay. Mr. Hammer, I'm going to find that there's probable cause to go forward with the case. As a condition of your bond, you're ordered not to go to any Target whatsoever for any reason. If you violate these conditions, if you pick up a new case, I will put you in jail. No more PR bonds for you. Do you understand me? Do you have the ability to hire a lawyer? Well, how do you support?
Okay, and then it went dark. Let's see when they pick up again.
Well, I don't even know. Let me hear it first and then we'll.
On December 1st, 2025, in Harris County, officer conducted a traffic stop on a vehicle for expired registration. The driver of the vehicle was identified as the defendant. The vehicle had 2 other passengers. While speaking with the defendant, officer detected a strong odor of marijuana emanating from the side of the vehicle. A PC search was conducted. Defendant informed officer he was currently on probation for aggravated assault. During the search, officer discovered a firearm located on the rear passenger floorboard underneath the passenger seat within the arm's reach of all 3 occupants.
Okay.
I'm arguing he's a driver, he was not in passenger.
Well, I mean, he could theoretically put his arm, what did you say, was it AR?
No, Judge, just a firearm. The pipe was a Glock 17 handgun.
I mean, you could theoretically just kind of put it in back and then someone else just kick it under.
Theoretically, the backside is under the passenger side, and I'm looking that is quite reach the country to that create not areas to fall. There's also somebody sitting in the passenger. He doesn't more than likely.
Did anyone else claim ownership of it?
I don't have those stats in front of me.
Yeah, I don't know. I mean, what do you think?
I think without knowing anything else like that, based on the dents alone, it probably causes us to say, move your legs potentially, let me slide in the back seat.
I mean, yeah, I think unless, I mean, if you show me that someone else claims ownership of it, then that's one thing. But I mean, you could, if you wanted to, just put the gun under there and just kind of, sorry. Yeah.
Thank you.
Yes, ma'am. Mr. Porras.
Good morning, Judge.
Hey, good morning. Yeah, of course.
How are you doing?
What's up? Who's your guy?
Approaching on Marco Washington, Judge.
That's right.
I would assume this is an attorney who does not mind being on screen.
So there's one violation, Judge, in the box on the column or?
Do you have anything to show?
The rabbit hole, I could think is.
Oh, sure.
Washington. Thank you. So, Judge, as you remember, this is one that I approached to restate his bond about a week and a half ago, maybe less than a week ago. We reset him, or you reset him at that time to May the 6th, to do a drug test on that day to make sure that he was clear on that day.
Say it again?
You had reinstated his bond, upon my request, and then you reset him to May 5th to be here. Typically, you're on, as you know, you waive appearances, but you wanted him to be here on that day to do drug tests on that day.
Yeah.
And you told us.
Well, that was for marijuana.
That was just my understanding, is it's a drug test. The drug test is a drug test. You said,
Sure.
when you explained it to him, Judge, you said no weed, no cocaine, no methamphetamine, nothing.
Right.
Okay, so Your Honor said on that day that we were going to bring him back specifically on the 6th to get drug tested, and on that, so he came back positive. Your Honor would forfeit his bond. As you can see, that report, Judge, that you have in front of you, if you got the colored version, there's 4 red lines that say positive, Judge. However, on the bottom where it's on notes number 2, the confirmed positive or the carboxyl THC and
Mhm.
which are the metabolites that can stay in your body for 10 days, 14 days.
But no, 2 to 6 days.
You can do a quick search.
I did.
on Google,
Said 2 to 6 days.
depending on usage.
He's not supposed to have anything in his body.
I'm saying, but what I'm saying, Judge, those are not active ingredients or active compounds at the time when he's doing the drug test. Judge.
He's got
These are-
cocaine in his system. Victor, he's
Your
not
Honor,
supposed to have anything in
I
his
understand
system.
that, but a quick Google search will show you that this specific compound is staying in your blood or it comes out in urine 10 days, 14 days, depending on usage.
Come up, Mr. Washington. Deputy Williams. Can't. It's a second bond violation, man. It's, you know, we do what we,
Well, it's technically a first, Your Honor, because this is the one where we spoke about this one where on that specific day when he was supposed to go,
Oh,
he also
right,
received it.
okay,
the notice.
get it. He's still testing positive for cocaine though, man. You know?
Your Honor, but on that day, you said on May 5th, or excuse me, May 6th, when we come back, on that day, if you test positive, then I'm taking you. That's what you told us, Judge.
What
This,
is this person actually arguing that he was only at risk if he tested positive on that exact date? I'm quite sure that was not the condition.
Still testing positive cocaine.
this is not an active ingredient, Your Honor, is what I'm saying.
I don't know, but I don't agree with you. It's 9 days after the fact. He's still testing positive. You're going to jail. You're not supposed to be using anything. I mean, I can't continue to reinstate. No.
Well, you're not continuing to reinstate, Judge. The first one should have never been forfeited to begin with, or revoked to begin with, because there was that miscommunication, Judge.
Yeah, I'm sorry. It's 9 days after the fact. I'm not going to just continue to, you know, he's got to know that we mean business. You know, sorry, Victor.
Okay,
His bond right now is at 3,000. I'm doing it 5,001.
Be at 3,000?
It's 3,000 now.
Can we do 3,500? I mean, again, this is the first violation. The first violation, which raised it from whatever it was to the 3,000, should never happen.
I'll do 4,001. All right.
Okay.
All right.
Thank you, Judge.
All right, man.
Yeah, you kind of only test positive for cocaine at an absolute maximum 48 hours. Absolute maximum. Usually it's gone within a day.
So 4,001 on Washington. Hi, Anna.
Yeah, his attorney is fighting hard for him. And so kudos to him. But, yeah.
Tell me something nice. Right. Touche. All right. So what's up?
I'm here on Audrey. It's good.
Okay.
So she's got an ER. And if you recall, Judge, this is the one that you wanted to talk to her on Thursday. She had a interlock issue. However, it's dealing with pretrial. I'm not sure exactly what happened.
Yeah, they gave her another PR bond. That's what happened.
Well,
Okay.
and
Where's Miss Taylor now?
I'm sorry.
Where's Miss Taylor now?
She's.
It's not. It's not.
So with the interlock violation, I'm not sure exactly what happened. I don't know the trials right on my head. It's all a pre-trial.
Did she even have an interlock in the car?
Yes, she had an interlock.
Oh,
So he's just a bond violation. He's blew,
or if there is an interlock in the car, blow into it, and if it doesn't register alcohol, you can start the car. Now, that doesn't stop people from starting to drink after or have a friend do it. So I had one of these cases that this is, again, when I talk about the cases where I represent people, yeah, despite my appearance today, my Easter appearance, I do labor and employment law. I've been doing it for closing in on 35 years now. This has happened more than once, that a forklift driver, a truck driver with one of these apparatus they get somebody else to blow into it for them, or they wait and then start the truck or forklift or anything, and then they start drinking. It's scary how many of those cases I have had where I had to represent those people, getting them away. Okay. Treatment. But for some people, they don't respond to treatment. And I had one person this would have been his 5th treatment, a month away on a treatment facility, and he said no. And I fought like a maniac to get him into that treatment home, and then he just said, no, I don't want to go into treatment. And it happened more than once, folks. And on one occasion that in my recollection is 2 years later, they found him in his apartment, bedridden, with foul vodka, not in a bottle, but in more or less bag-in-box at the side. He hadn't left his bed for 4 months. He had a person delivering it. Foul vodka in bag-in-box. So they had to get him to more or less hospice after that. And he just didn't want to get sober. Genuine nice guy. Intellect, but he didn't want to stop drinking. Yeah, at least he wasn't driving. And yeah, folks, alcoholism is really, really dangerous.
But based on the timing of it, if you look at the time zone, because like, what, at 6:08, it was a 0, and then at 6:15, it was a 0.03, and then she blew again at like 6:58, and it was a 0. So I don't know what happened, but
She's supposed to retest immediately, right?
it was the rolling testing. So she was explaining her like currently driving and she was after driving. And so that one is like
How would it start and let her drive if she blew a 0.03?
it's because her first flow was a 16. Okay. So that allowed her to start the car and it was a 0.00. And then she was driving also 0.3. And then
Oh, I see. Okay, so she blows at 6:08. It's a 0.
Oh.
Then she blows a positive 0.03.
like 7 minutes later. And then it had her blow again and like another 30 minutes
Okay.
is a 0. And just, I don't know what happened, but that.
Okay, so that's strange. You don't start with a 608. 7 minutes later, you go to 103, and then you blow 0. That sounds like malfunctioning device.
It's embodied as a process.
I get it. There must be a false positive or something. I mean, how else could it happen, right?
Exactly.
I mean, even if she had blown.
Because she blows a 0 at 6:53. If it's a rolling, would it really wait from 6:15 to 6:50 to test again? That's weird.
The guy should have figured out tested in 15 minutes.
Right.
And so there's no reported failure.
Did it prompt it to?
I'm not sure.
Can you look to see if it did?
Well, usually if they
Yeah, I mean, 608 is an enormous number. 103 is a high number. 608, I mean, no. So within an hour, you go from 608 to 0. That's a malfunctioning device.
miss a blow, it shows up on the report as a miss or skid.
This is really weird.
Yeah, this is weird.
I'm gonna see, I'll please, so you can raise the device company to see if you have any explanation for it.
Yeah.
But this human body doesn't process
But
it.
regardless, how do we go forward when she's driving on a suspended license anyway?
So, as far as that goes, Judge, I'm gonna help her with an operational.
But she's still driving on a suspended license.
Well, she's not driving now, but she's aware of it. She did.
Because she got arrested again. It's a third arrest.
Yeah.
Now, she's on deferred for an aggravated assault, picks up DWI, and now we have
Driving without a license on top of that.
Judge,
Yeah.
just for the court's awareness, normally when I get appointed on the DWI, I go ahead and do the driver's license.
Did you do the LR hearing in this one?
However, in this situation, it was dismissed and refiled because of the paperwork snafu. And so by the time I got it.
What paperwork's now?
The officer left something out that, for PC. And it was before the judge found PC, they dismissed. And so by the time I got appointed on the case, we were outside the window. And it found.
But she's had enough DWIs that,
Well, she was arrested for one previous one that was dismissed. It looks like she has 3 total DWIs, 3 DWI arrests because one of them was dismissed and refiled. And had I been appointed within the window, her license would not have been suspended because it was a failure. But what the officer did was he took 2 incomplete blows and put them together to make one pass. So had we done the ALR, not.
is that justified?
I don't know that it justifies it. She said that she did not get a letter from DPS
Happy Easter.
about the ALR suspension. It's DPS, so
It's currently suspended now, right?
it is currently suspended.
I could consider running her license right now.
But now that she is aware of it, she's not driving. She had someone bring her to court.
So I'm gonna amend the condition to put a scram on her, because I want to make sure she's not drinking. I'm gonna leave the thing on, because I want to make sure she's not driving anymore.
Okay,
I'm at wit's end.
okay.
Like I can't, it's just way too much drama, and I'm ready to like set the trial. It's just
Oh,
way too
and that's
much.
what I would like to do. Is that-
Well, the suspended license case is just way too early. I mean, it's only
Okay,
not even 3 days old. I can't set that for trial, but
okay. And I-
are you ready on the DWI?
Sorry, Judge?
Taylor, are you ready on the DWI to set it?
I haven't had too much of a chance to look at it. I haven't detailed it yet. I would like more.
So I'll give you a week. I'll set for a week. Take a look at everything. Be ready, because it's just way too much drama. And I'm,
Okay. And Judge, since she's been previously found indigent, can I file occupation in this court and waive the filing fee? To get her driving legally?
Yeah.
Okay,
yeah, I'm okay with that. Sure.
maybe excuse me.
Yes, ma'am. But it's the no tolerance. If the slightest,
Okay, understood.
okay.
Yeah.
Yeah. Good morning, Mr. LeGrand.
Good morning, Judge. I have Justin Nesbitt. It's an arraignment on the docket.
Hey, do you mind hitting the button on the soundbar? Just give me 1 second, Mr. LeGrand. It's not working. Just one time. All right. Say something.
Justin Nesbitt. It's an arraignment.
There we go. Okay. You just want to reset?
Yes, sir. It's a racing on a highway case.
Got it. Do you see an attorney record? Did you file guys on you did? Okay.
Well, if there's other company, they're still missing. Well, I want to say that. I want to say. Okay, so we say that.
Yeah. And for anybody who realizes they are alcoholics and got sober, congratulations. Keep going. Keep going.
Yes, I'm not waiting it anymore. Just way too much.
Okay, yes.
You know what? Don't worry about it.
Okay.
It doesn't need to.
Wait, she'll probably be there anyway.
No, you can waive it. I mean, you're just setting it or, I mean, unless you guys are planning on doing something like she's going to take a plea, then yes.
Okay.
But otherwise, just waive it. There's no need to have her here.
You see them? Oh, yeah. Let's make it a reset to me.
Hey,
Yes, sir.
Nesbit, I've got Mr. LeGrand here. It's just a reset.
House, May 19th to the 21st.
Did you hear that? You're muted.
I haven't done this in a while, Judge. The 21st is great.
Wednesday.
21st, yeah. Okay, and it'll be waived for that one, okay?
Okay. Thank you, Judge.
All right, man, have fun.
All right.
Take care.
Bye.
Come on up, sir. I mean, it was like a charm. So I put something else. I didn't want to do it. So everybody else will do
I need a smoke in here.
I think that's all of them. Sorry. Hey, oh, I'm sorry.
No, you're fine.
Just yell next time. Hey, good morning.
I'm here on Mr. Watson.
Okay.
Mr. Watson. Charlie, I guess maybe.
Shut the front door. He picked up a new case.
Well, actually, this was filed on March 24th, but it says that the offense was on January 27th. And they just chose to file it, I guess, 2 months later.
Where's Mr. Watson now?
He's here, he's in the box.
Marroquín. Marroquín. Oye,
Do we have PC?
Yeah, sure. Okay.
Slow Sorry.
Lord have mercy.
They do it for your entertainment.
That's right.
On the
Yeah, the newest one. Now number 4. Do you have space back there? You got space?
We have enough space.
On January 7th, 2026, in Harris County, officer review a Pasadena Police Department report of an assignment of case follow-up investigation. Contacted the complaining witness, store manager of the academy, located off of Beltway 8 in Pasadena in Harris County. The complainant stated that on January 27th, the defendant entered the store and that the complainant had received a clock alert on his cell phone indicating a known suspect vehicle and past prior academy thefts had entered the store parking lot. The complainant later found the defendant was concealing items under his clothing and observed him exiting the business without making any attempt to make payment.
Wow, those flock alerts, huh? Cool. Wow.
The complainant reported the defendant fleeing the same vehicle he's previously received a clock alert on. and advised officer that he observed the defendant walking towards the front of the store with blue and pink articles of clothing hanging out from under his clothes. Additionally, he observed the defendant almost dropping those items, which led to noticing the concealment. Complainant advised officer that he returned to the area where he noticed particular shirts on display, and discovered 3 hangers on the display rack missing the articles of clothing from them. Complainant confirmed those items.
Come up, Mr. Watson.
They were the exact items observed concealed on the defendant when they exited the business.
How much?
So they were 3 shirts valued at $59.50 each. So they don't have the total in the pins, Your Honor. But
What is the date of this one?
I'm sorry.
So this one is January 27, 2026.
Yeah. I know, I'll bring that up. I mean, Mr. Watson is just telling me he's been on an ankle monitor since before this charge, so I don't know. I mean, I know that ankle monitor gives you a location.
Well, he's been an ankle monitor now because he's picked up 3 cases and he got it prior to his release. But yet we still have case after case after case.
I don't know if the monitor itself was tracking like a barrier location of that academy. I don't know if that was part of the on conditions. I know that he had a no return to academy, and at the time.
Hey, horse welfare. Who is the cat in the bottom right? Mr. Jingles? No, that's not Mr. Jingles. That is Dolly's cat. What? It's one of these weird breeds. It's an Aussie cat. It's a Babu, the Aussie cat. So it's Dolly's cat. I'm currently using Dolly's, because Dolly does this every Monday through Friday. He has this court watch where he streams different courts and judges, and if one goes to a pause, he jumps over to the next one. And thank you so much. Thank you so much.
And that is officer allegedly, or the person, the complainant allegedly saw this happen, Mr. Watson would have already been arrested, and I'm assuming they would have been followed up with about this charge. Actually, oh, this is a charge that even predates the other theft. So he would have been arrested on the new charge.
So I'm not going to revoke the old one.
Folks, I have the sudden... thank you, Derek, for your super sticker. It's of a suitcase. Yay! Thank you so much. Now, I'm kind of a bit jealous of Judge Fleischer's smoking jacket. Now, I did find this over at Temu at XXL, which is my size, which is my size. And the reviews are, well, I don't know how fake these reviews are, but it seems like they actually have, it is an actual size. So folks, let's see here. The cost of it is, where's the where does it say the cost? What does it say? Oh, let's say 402 Swedish krona, so $40 for this amazing red smoking jacket. Now, folks, if you want to help me out, I would not mind. I mean, I got $2 over at Rumble. I am at $4 over here, which is it's good on the way. How do you wash it? I assume you don't. Let's see here. It's polyester, of course. How do you wash polyester? Yeah. Cold water. But it also have these palette kind of things. I reckon it's $40 for something that I can use once in a while without Hey, folks, it's a Temu. No, I did check different kinds out, but I mean, it's either more expensive or it's just one review. Okay. What I did was I searched on smoking jacket Hugh Hefner triple XL. That is what I searched for. Now, if you can find anything on that, I think the judge's jacket is velvet. Let's see if they have smoking jacket velvet triple XL. Oh, look at that. Hey, look at that. And triple XL. %93 says it's normal size, so it should fit. Hey, look at that. You have an actual. This is an AI picture. Don't trust it. So it's a blazer, velvet blazer. Yeah. So if we today get to, YouTube takes their cut, we need $60 in Buy Me a Coffee, in PayPal or Supers and stuff for one of these, or 120 for both. Let's just see how it goes, because it might just be that I choose to purchase both of them. But if you wouldn't mind, if you want to help out with a few bucks, I would be so grateful. I would be so grateful. Yes, I know that's not what you get, but folks, you will be here when I unpack it. You will be here when I unpack it, or unbox it. Oh well, let's get on with it and see what happens.
Actually, the weed case, I will leave alone. Actually, the felony's not my case, but the theft case, he was on bond for that case when he picked up this case, when he picked up the weed case. So I'm not going to touch the weed, but I think that the prior theft, he was well on bond for that one. He's been on bond for that one. Actually, no, when did he make bond on that?
Actually, no, I lied. The theft was February of last year. This new charge is alleging January of
This is this year, right?
And I mean, Mr. McLaughlin didn't read this Jim was very weird.
Why?
Very weird. He says that he saw articles of clothing under his shirt. He only describes them as pink and blue articles of clothing. But he says that he can identify all three articles of clothing. He makes no description of what these articles of clothing are.
Well, regardless, it's still over the
Well, what I'm saying is
threshold.
that it's interesting to me that he can identify which pieces of clothing they are if they're stuck underneath his shirt.
Sure, and that's great, probably for a jury, right? But for purposes of probable cause,
Officer also reviewed surveillance footage. I just was.
there's also surveillance of, yeah, Mr. Watson.
Well, he doesn't, I understand, he doesn't describe the surveillance, he just says the surveillance reflects the story. He also apparently, I don't know why they're having to do this roundabout way of identifying him. Apparently he was stopped by another officer and he reviewed that officer's body cam footage and I guess compared it with his booking photo. So I don't know if they compared that to the surveillance or not. I guess they compared it to the surveillance video, but this is a year after he's been in custody on this theft. I don't understand how they do not have information about this person.
Oh. A year?
Also, this isn't for PC, but I know that we can get a list from, unless they delete the GPS information of basically every time Mr. Watson left an area and went to another area. They track it by the exact address. I know it's not going to alert when he goes to an academy. It's going to tell us if he ever went to that academy. I don't know how about
Regardless, I'm going to find that there's probable cause, and I'm not going to give you a PR bond. You will be going to jail today, Mr. Watson, and I don't know what I need to do to just.
Why would I throw these homes not to go to an academy at all? Why would I do that? That would be the dumbest thing I could ever do. You gave me the bond condition. I already messed up.
Don't. They've already
Don't
filed
talk.
it. We'll see the surveillance. I don't know. That's nice.
Yeah, kid, probable cause. Then they have to show it. You can file a motion to dismiss. You can make claims. That's not this hearing. That's not this hearing.
Mr. Watson, that's nice.
It's just upset because you have no idea that he had this warrant. I mean, I know they don't alert you, but he came in here as deputy and told me warrant. I had to tell the court we have a warrant.
I didn't know either, but at some point there can, and I don't even know, maybe there's more. I don't know.
Did we set a bond, Judge?
I'm going to, I don't know what though. I don't know what. Give me a second. Let me talk to them, get them on, then we'll discuss.
Garrett, just quickly, Your Honor, I've got Deja Turner, she's got a BVR. I need to look at the data and the pretrial officer saying I can't get what she has. It's not in my email. It's not in images. She said if you said I could look at it, then I can be better prepared.
So here's what, I'll set you for a formal bond hearing this coming up Monday.
She's here. We were set for today.
Well, you said you need records.
She has them. I'm ready to go for today if we can get, if I can just look at what the evidence are. But
Ask Ron.
You're either gonna chew her out.
Well, here's what I'm gonna do. I mean, I'm gonna put a device on her ankle now.
Okay.
To scram. And any further violations, that's it.
Okay, do you want an explanation? It's not gonna change probably what you put, do a scram or not, but do you care to hear? I haven't, okay.
I'm giving you another chance now, but if it happens again,
thank you.
I'm gonna lose my, you know what? So, and then I'll pay for it too.
Thank
you. Okay. Hi, Brandon. Good morning. Okay.
Say the statute.
Oh, yeah, please. I thought that was it.
Yes.
Oh, he doesn't speak English. Okay. Mr. Ibarra, you were charged with assault. Shh. You were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On March 23rd, officer in Harris County responded to an assault call. Officer on scene advised that he was flagged down by a witness reporting a male in a truck hitting a female, striking her several times. Witness pointed to the truck, which was leaving the parking lot. An officer conducted a traffic stop on the vehicle. Officers observed a strong odor of alcoholic beverage from the defendant's person and red glossy eyes. Complainant advised that she was in a dating relationship with the defendant and they had a child together, which was in the rear passenger seat of the motor vehicle.
Oh.
The child or the
child?
Okay.
The complainant advised officers that the defendant slapped her across the face and that she felt pain. Officers observed
women. Now, your heart, men as well, this goes to either. The heart says one thing, yeah, sure, date a felon, but the moment there are violence or threats of violence or psychological violence, get the fuck out. It will not improve. It won't improve.
red marks on her cheek. Defendant advised that he has 10 Modelo beers. And they did SFSTs as well.
So you have a witness that's able to identify and see and corroborate that it happened.
Yes, Judge. The complaining witness is in the passenger seat.
Yeah.
So you already got felon condition against the portable bike.
I'm going to order him not to consume alcohol or illegal drugs, but I wasn't going to do any kind of device.
Yes, sir.
Mr. Ibarra, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. There's a protective order that has been issued and you need to get to know it. If you violate the protective order, the state can and probably will file a violation of a protective order against you. That is one of the worst misdemeanor cases you can pick up. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody for a long time. Do you understand?
Yes.
Don't have contact with this person. I don't care what you need to do. I don't care that you have a child. You cannot justify contact in any manner. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Strauss. Mr. Strauss, if he tells me he cannot get a hold of you, I will revoke your bond. For now, I'll get you to Victoria, sign a reset. You'll get with Veronica for your bond conditions. And after that, you're free to go.
No, thank you.
Okay, you're representing him upstairs.
Yes.
Okay, great.
All right, I
Okay.
didn't go to the first one. It's
Yeah, okay.
Thank you, Judge.
All right, good luck. So just no alcohol, no drugs, random testing. He's got a monitor upstairs, so if they see any BVRs, let us know too. No contact, no weapons with the complaining witness. That's it.
Thank you.
Oh. If he doesn't have a license, no driving. Okay. Joe.
Yes, sir.
Hi, bud.
We got a Martin Chop today.
What's the last name? Oh, Chuck.
Chin Chop. PHENCHOC. A Martin Chop.
Where are we headed? with
Okay,
this?
so this is where we're at. He's taking the T-RAS tomorrow. Someone asked for a walkthrough today. He had a BBR because his phone broke. He's got a new phone. He
The
came on
PTO was denied though, right?
initially, but then on the 17th,
I feel a bit hungry, so I'm going to grab myself a new piece of pickled herring with mustard and peri peri hot sauce. That's so nice. Happy Easter, folks.
Chief Happy, granted it because they couldn't, there is no restitution. They did the RIP, there's no restitution, so we're good on that. That day, she okayed, PTI, so we scheduled the T-RAS for tomorrow. In between then, and that's why he had a skip test. He has a new phone, he's given that pre-trial. We came on Friday, you weren't here, but he was ordered to take a test, came out negative, so he's okay.
Okay, all right, we'll just continue supervision now.
Can we do the walk with the T-RAS?
Yeah, today. Yeah, for sure. And then we'll set you like 2 weeks.
Okay.
Okay, bye, Joe. Kobe, you ready?
I think we're good, Judge. I thought I had approached, but it looks like they've already been in front of you and gotten lots of bishops, not 2 clients, so.
Easy money.
Thank you.
Mr. Johnson. Antoine, you're muted.
All right. I was just notifying the court I was coming in from Walker County. I was set for trial out there, but didn't want to file a Harris County continuance because I've set that trial 4 times and we never go. Anyway, I'm coming back in town and just wanted to let the court know that I'll probably be like 30, 45 minutes.
Who's your defendant?
Anthony Brandon today.
This is so nice. Yeah, Judge, I'm on my way. Doesn't happen that often. Didn't we hear this part already? Some cases are very similar.
Was it in jail? I think it was Brandon. Yeah, Brandon is the last name in jail.
Okay.
Let me see.
But I won't be that long. I'm actually seeing downtown now, so I'm probably, 20 minutes out.
Oh, hey, this is a no PC, I think.
It was. It said defendant was discharged, but still wants to make the
It
appearance.
says defendant discharge. What the? Hey, what happened on Brandon?
What happened with Brandon?
Weird. Unless it's a
It's filed, it was under the amount that we filed, that was filed at intake, 189, filed as about 750.
Oh, that's right. What do you guys want to do? I mean, he's we're holding him, dude. But
I'll this right now.
okay. And then, yeah, if you're going to refile it, but at least, I mean, he's made bond on the felony case. Before we were here last time, he had not made bond, right? Okay. Hey, they're going to dismiss it. Antoine.
Perfect. Okay. Thank you, Your Honor.
Okay.
So
okay. Thank you. I appreciate it.
Yep.
Take care, man.
Bye-bye.
Yeah. Good luck to you, Brandon.
Do you hear that?
Dismiss.
Brandon, they're going to dismiss it. Yeah.
All right. Oh yeah. Anyone seen Let's Go Brandon lately? It's been a good while since Let's Go Brandon was here. I've seen him occasionally at other places. To my knowledge, he has medical issues, and that's all I know. That's all I know. So if you're around, Brandon, we all hope you get better. Yeah. I think I saw him on Nick Ricada not that long ago. But to my knowledge, he has had some kind of medical issue lately. I hope he gets better. And that it shows up here. That's great to hear, Amica fan. Doing a lot better. That's great. Background noises. And okay, Judge Fleischer went out. Okay, so let's jump into Judge Middleton.
To work. And for most people, that's very important. You can drive to work, school, treatment, court, other limited purposes, as opposed to an outright suspension. You understand?
Yes, sir.
Now, the other charge will require the forfeiture of your gun or guns. Do you understand that?
Yes, sir.
Did anybody threaten you to get you to plead to this charge?
No, sir.
Or promise you anything?
No, sir.
Do you understand that by pleading to this charge, you'll be giving up all the rights that you indicated there on your advice of rights?
Yes, sir.
Now, I see some promising things that your lawyer has given me. You're connected with Pivotal, and that's a plus. And looks like you're plugged into the Vicksburg AA group.
Yeah, I've been doing it since February.
Good. I've got a lot of people in our county that like Vicksburg AA, meet 7 days a week at the community center there. Some of my sobriety court folks are going over there. I knew a man.
Cat! Happy Easter! Happy Easter! Good to see you. Good to see you. Happy Easter. Happy Resurrection Day. Love the hat. Yes! Thank you. Thank you. Now, usually I'm Santa Claus. Today, I'm Chicken Pope.
And just knew him. And he got arrested and got plugged into Vicksburg AA and really liked it over there. Now, you live in Three Rivers, but you've disconnected with the AA in Vicksburg?
Yeah, I grew up in Vicksburg. I heard a lot of good things. Pivotal recommended it for the moral support.
Well, that's a good start. We've also got some good AA here in St. Joe County. The biggest one is at the Carver Center. But all right, well, let's talk about this. Let me pull this up. Now, one thing I'm sure Mr. Gibson told you, if you plead to this charge, I'm not able to sentence you today. I have to set up for what's called screening and sentencing. So we'll pick a day that works for you and your lawyer, get more information about what you're doing before we do the sentence.
If I may give the court some information, the defendant, as part of his job with he works at Ox Engineer and he's been there over 30 years, and he's actually he has to go on an overseas trip to China, and so he's going to be gone April 9th through April 20th. So we would ask that the sentencing, I guess, works around, I guess, that date period.
All right, very good.
Sounds like a long trip to me.
I've never traveled, so.
Well, you don't do a weekend in China, so my kids have all been there. I have not. Did you live in Schoolcraft at one time?
Yeah, 10 years.
All right, but now you live in Three Rivers?
Yeah. We had a house built just outside of Three Rivers.
Off M60 there?
Right past the airport, yeah.
Okay, yeah.
Right in that cul-de-sac area.
Did you have that little steel one built?
No, I'm behind that.
Okay, not the big steel one. There's a small.
Oh, no, that's
just around the corner. It's a ranch style.
Okay, there's a cool little small steel one there.
Yeah, my wife and I walked past that the other day. It's beautiful.
All right. On December 6th, in Park Township, out by the dairy farm, did you crash into a barn?
Yeah, I didn't have, I was having a panic attack and I didn't put, it's a spin knob on my truck. It's different than on the floor. I didn't put it in park, and when I let off, it rolled into it. It didn't do any damage, but.
All right, and how'd you happen to be out there?
Panic attack
Well, if you
in
don't
a
remember.
lorry?
Your Honor, we're asking for a no contest plea because he has a very, I guess you could say, hazy memory about.
All right, well, let's see what we do remember. Were you drinking Jameson?
Yeah, I was.
They gave you a blood alcohol PBT and it was 0.233.
0.233. Panic attack? Yeah. Did you fall asleep and didn't have your parking brake in on?
Yeah.
Well, impaired driving is a real gift.
Yeah.
And did you have a handgun in the car?
Yes.
Oh.
We've been moving everything out of our storage unit and out of my safe, and I had generator in the back. I had a bunch of stuff, and the reason I was there is it's 2 miles from my house. I just got the Jameson, and wife didn't want me there, and ultimately I drove off without my keys. She's had them, but I drove off and went out there. I grew up on a farm, and the cows were nice, and there was no one there, and I sat there.
Well, it's stinky out there.
It is, but it's what I grew up on.
All right.
Cows don't stink.
All right. Sounds like you need some attention. And I saw like this was a big wake-up call for you, and maybe that's all a good thing. You don't seem to have much of a criminal record. I wanted to look at your
No, I've
truck.
not been in trouble before.
Well, then maybe we're lucky that nobody got hurt and we got a chance to. No, for reasons I don't understand, there's not a driving record in here. What address is on your driving record?
Probably my son was 6, so I did get a speeding ticket. I think.
No, but I mean, is your driving record still say Schoolcraft?
Yeah, I had an appointment.
Yeah, you need to change your address because
I did go in and change it, but they wouldn't give me a sticker. They said, depending on today.
Well, because any mail, we don't have a driving record in here. Any mail they send to your address on your driver's license.
I did change it.
All right, very good.
I made an appointment, went to the Secretary of State, and I did change it, but they didn't give me the little.
Well,
sticker.
and you're in a tough spot because you got a paper license, correct?
I actually got my real one, but I got a paper one with it.
All right, so it's there because when you fly in an airplane, they want to see your driver's license. Now you're going to China, so you'll have a passport also. But heaven forbid, if you get arrested for drunk driving right before you have to take a plane ride, you're in this funky paper license business. Anyway, you should be all right.
Thanks for thinking of that. Yeah. Like to come back.
Yeah, they won't let you back in. You'll be stuck in Guangzhou. All right, I'll accept your plea. I have enough facts from you to get the fact that you had been drinking, you were a 233, you were driving the car, and you had a gun. So although you don't have a clear memory, I have enough to accept your plea.
Yeah, you're lucky. It's your first offense. Hey, Donnie. Donnie's back. Hi.
All right, let's pick a date here. We probably have to go out to May. Paul, are you available on May 4th at 11?
Yes, that looks okay.
Should be warm enough by then. What I'm going to do is I'm going to give you some paperwork to take out to the counter. They will get some information from you, get this for screening and sentencing after you get back from your trip. Now, the bond says you can't leave the state of Michigan. You have the authority of the court to go on this business trip. You're not going to abscond and stay in China. So I will note defendant has court permission to leave the state.
Thank you.
Mr. Verwey, I can.
Oh, Danny Extreme. Thanks for doing this, Nick. I had to miss family plans today. Thanks to work. So it's really nice getting off to hang out with you now. Hey, what can I do? I mean, I'm 6 hours ahead of you guys, at least, and done the things I needed to do today. So I thought, yeah, I haven't done one of these court hopping things in a while. So let's do an Easter stream. Now, tomorrow, I'll probably continue reading from the Delphi case. The state has replied to the appeals brief, and it's really, really, really bad. The crap the state put in there. And then also I have an update on the Michigan hyperbaric chamber case that I need to get through. So I will get back to you tomorrow with the cases I actually cover.
Tell just from what I've seen that you were at a low point here. I see a person that was depressed and self-medicating. So I think we're going to get to a better place. Anyway, there's probably a probation in your future. We'll find out more about this. I'll indicate I need driving record for file. Court officer will take you out. You can meet with the clerk. They'll give you a date to come back for your sentence. That'll be the 4th of May at 11 o'clock.
For the sentencing. The probation department. Just to confirm that there doesn't be like a little bit of call.
All right, let's see.
Hello, Sergeant Herman. This is Judge Middleton calling. I can't see your records anymore. Can you tell me how many jail credit days Elizabeth Conway has? Well, we could just go from the date of her.
LLP. What happens now that the state has replied in the Allen case? Now the defense can reply to their reply. And they have a lot to reply on. How the state omit a lot of facts, and especially how they try to change the facts that were testified to in trial. That is going to be a huge thing. How they, how the how the Attorney General, in their reply to the appeals brief, changed what was testified to in court. That, I believe, will be a huge thing. But they have 30 to 60 days to make that reply.
Arrest. It's a pain for us, so hopefully we'll get something up that we can get at. All right, I'll figure it out. Well, I wasn't clear, so it looks like she's been there since the 9th. Date of the offense is the 9th. All right, today's the 27th. All right, that would be 18 days. All right, thank you. All right, bye. They can't tell either. This new system, they dismantled the one that worked before they got up to one.
Mobile control doesn't work for us anymore.
What? No, mobile control is defunct, I think, but we had it's called web jamming. We be jamming. It's shut off, and we use it every day to determine who's in jail and who's got issues, and do we need a bench warrant arraignment? What's the bond? How many days do they have? All right.
Not that unusual anywhere with, hey, politician says, yeah, we're going to get this new system and it's going to be amazing. And they pay a fuck ton of money for absolute shit. We have one of those change of systems over here as well. Currently, they have spent close to $1 billion on this new system over the past 5 years, and it still doesn't work. Not joking. 10 billion Swedish krona, which equates to $1 billion for our jail system thingy. It's amazingly bad.
Are you ready on your case, Mr. Bush?
There's a number of them we can take care of.
Well, let's take care of Pablo, and he's joined us. We have had some issues with sound going in and out. Laura, would you join me now to see if we can see what's going on? John, I don't have this case.
Oh, I'm.
Jabs, they might have to remote in some settings on Zoom.
All right, that might help.
Maybe I didn't get that.
Let me get it from Autumn.
Yeah, we all hope Rick gets the trial he deserves and not the kangaroo court he got. Okay, Judge Middleton is.
Really? We got Pablo's door. All right, everybody, good morning. We are in the thick of it here. We've got a number of pleas we're going to take as a result of the pre-trials, and we're in pretty good shape. Miss Abby Stoll is joining us from the prosecutor's office. Appreciate her help also. All right, the matter we're going to address are several files regarding Daniel Gonzalez Jimenez. Is that you, sir?
¿Es usted el señor Daniel González Jiménez, señor?
Sí.
Yes.
You have some cases that were charged under Sturgis City Ordinance.
Usted tiene varios casos donde le imputan delitos de acuerdo a las ordenanzas de la ciudad de Sturgis.
And some cases that were charged under state statute.
Y otros casos le están imputando delitos bajo los estatutos del estado.
You got charged with drunk driving twice.
Le están imputando el delito de que estaba usted manejando borracho 2 veces.
In file number 24315OD.
En el expediente 2435OD.
You got charged with operating while intoxicated in Sturgis.
Y le están imputando el delito de que estaba usted manejando borracho en la ciudad de Sturgis.
Then you disappeared for a while.
Y se desapareció por un tiempo.
On that day, you also had no valid operator's license.
Ese día que lo detuvieron, no tenía usted una licencia de manejo tampoco.
Then you got arrested on April 14th for drunk driving.
Y en abril 14 lo vuelven a detener por manejar borracho.
Again, that was in 2024.
Eso fue en el 2024.
Again, driving with no valid operator's license.
Y de nuevo no trae usted una licencia de manejo ese día.
Then, in 2025,
en el 2025,
on August 3rd of 2025,
agosto 3 del 2025,
you got charged again with operating without a valid license.
lo volvieron a detener y no trae una licencia válida de manejo.
Operating while intoxicated is a misdemeanor in Michigan.
Manejar bajo la influencia del alcohol es un delito menor aquí en Michigan.
It is punishable by up to 93 days in jail and a fine of up to $500.
Se puede castigar hasta con 93 días de cárcel máximo y hasta $500 máximo de multa.
It carries a fine of up to $500.
Le pueden dar una multa de hasta $500.
And it requires that your driver's license be suspended.
Si tuviera usted licencia, le suspenderían la licencia de manejo.
Right now, the plea offer is that you plead guilty to operating while intoxicated.
La oferta que le está haciendo el fiscal es de que se declare usted culpable de manejar bajo la influencia del alcohol.
On the February 18th, 2024 case,
en el caso de febrero 18 del 2024,
the city would dismiss the charge of operating without a valid license.
Y la ciudad le retira el cargo de que está usted manejando sin una licencia de manejo.
The operating while intoxicated file number is 24315OD.
El expediente en donde se registra que está usted manejando borracho es el 24315OD.
And that you plead guilty to operating while intoxicated in the April 14th case.
Usted se declaró culpable de manejar bajo la influencia de alcohol el 14 de abril.
24630.
Ese expediente es el 24630.
OD.
o D.
And again, the city would dismiss the charge of operating without a valid license.
Y de nuevo, la ciudad le retira el cargo de que estaba usted manejando sin una licencia de manejo.
The county prosecutor, Ms. Stoll,
el fiscal del condado, la señorita Stowe,
would also dismiss the no operators license charge from August 3rd of 2025.
Le retira el cargo de que estaba usted manejando sin una licencia de manejo el abril 3 del 2025.
If you plead guilty to these charges, I won't sentence you today.
Si se declara usted culpable de estos cargos, no lo voy a castigar hoy, no lo voy a condenar hoy.
I will set the matter for sentencing in a few weeks.
Voy a programar el castigo en unas semanas, la condena.
With the help of an interpreter, we can then do the sentence after we get more information.
Porque voy a aplicar el castigo después de que investiguemos un poco más.
Mr. Bush, what's your client going to do here this morning?
I just want to follow up on the plea agreement, Your Honor.
Yes.
I think it's also implied that there would not be amended super drunk charges as a result of this.
All right.
And he is going to enter a plea to the 2 OWI charges with Mr. George's office.
Okay.
El juez le pregunta al abogado qué es lo que van a hacer hoy. El abogado está pidiendo que te retiren el cargo de que estabas manejando súper borracho y te vas a declarar culpable de los 2 cargos de manejar borracho.
The prosecutor has also agreed not to charge you with the more serious charges of operating with a high blood alcohol level.
El fiscal está de acuerdo en no imputarte cargos más fuertes por manejar con un alto contenido de alcohol en la sangre. O sea, manejando muy borracho, dice.
John, do we have an advisor rights?
Están pidiendo si tienes tus derechos constitucionales. Tienen una hoja.
Mr. Jimenez Gonzalez, if you plead to these charges, you'll be giving up your right to have a trial. Understand that there will not be a trial.
Señor González, ¿entiende usted de que si se declara culpable, está usted cediendo a tener el derecho a un juicio?
If you had a trial, you would have the right to be represented by a lawyer.
Si tuviera un juicio, usted tiene el derecho a ser representado por un abogado.
Mr. Bush has been appointed to represent you.
El señor Bush es el abogado que te está representando hoy.
You could also hire a lawyer of your own choosing if you wished.
También puedes contratar un abogado si así lo quieres o quieres ir con el abogado del tribunal.
You'd have a right to a trial in each case.
Tienes el derecho a un juicio en cada uno de los casos.
If you had a trial, you would have a right to take the witness stand and testify in your own behalf.
Si tuvieras un juicio, tienes el derecho de testificar a tu favor.
You would have a right to have any of the witnesses, either on your behalf or against you, subpoenaed to come to court so they could be questioned under oath.
Si tuvieras un juicio, tienes derecho de traer testigos que testifiquen a tu favor y tienes el derecho a pedirle al juez que ordene que se presenten en tu juicio.
And you have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt.
Si tuvieras un juicio, tienes el derecho a declararte no culpable más allá de...
I have that advice already.
We are going to
Understand?
finish with this, and
¿Entendió,
then
señor?
we are returning to Judge Fleischer.
Also, it states on here, I understand that if I'm not a citizen of the United States, a plea or conviction could carry a serious immigration consequences, including mandatory detention and deportation. Do you understand?
También, si te declaras culpable de estos cargos y te encuentran culpable, podría haber consecuencias con el servicio de inmigración de que te detuvieran y te deportaran, que si entiendes esto.
Do you understand?
¿Entendiste?
This could have immigration consequences if you don't have lawful residency status.
Esto podría tener consecuencias si no tienes un estado legal, si no tienes documentos para estar en el país.
Do you understand?
Tienes que contestar sí o no. Te está preguntando que si entiendes. Yes.
Sí, yo me entiendo.
Yes, I understand.
All right.
Yeah, that has been discussed.
Okay, I just want to put it on the record. We didn't have a signed copy of that. All right, well, let's talk about these. If you want to get deported, this is a good way to try to do it.
Si quieres ser deportado, esta es la mejor manera de lograrlo.
All right, let's talk about the first drunk driving arrest in February.
Vamos a hablar del primer caso de que estás manejando borracho en febrero.
Okay. That would be Dali stopping and jumping over to another court. Let's see if he goes back to it. No, he won't. All right. Let's get back to Judge Fleischer.
Hey.
Just need to calm down.
What do you think is a reasonable bond for Mr. Watson, considering all the stuff that's happened?
Considering that the price is predated, even the P1 charge, you can see it on.
He still picked it up this January. He's been on bond for the last year for
All I'm
theft.
saying is that he paid for the POM, he paid it on the POM. It's not like he's trying to skirt the law. He came in here, he was taking.
But he's picking stuff up. We're now on number 4 that's open.
I know.
How do we get his attention? Not with, I mean, really, how do we get his attention?
I understand that she's claiming complete innocence for this, so I'm not gonna advocate for any exercise.
I get it, sure.
Council reset.
But nevertheless, we're still on number 4.
Understand.
What do you think?
I would just argue, so same amount of POM bond. Possession.
I think that's too low.
Okay.
But if that's what you're asking for, then that's what I'm gonna do. I was thinking 25,000, just like the felony, because I wanted him to understand that you just, but he asked for 10, that's what I'm gonna do. 10,004. Yeah.
Are we leaving the other bonds?
Yeah, because, I mean, the he made a bond on this theft case February, right? This was before that. The POM was obviously after that. But let me tell you though, Alice, if he picks up a fifth case, I am truly that it's gonna hit. Just so please advise him accordingly that if he doesn't live like a halo above his head, okay?
Yes, sir.
All right. Obviously, no going back to the first step was at Academy as well. Right. I wonder. She's talking to someone. I don't want to
Space and I feel I'll read your perfect bomber and turn it into a perfect system.
Hey, Veronica, is there a way to put some kind of alert where if someone goes to an academy, any academy, that you would be notified? How do we do? Is that possible?
I do know that there is a way to cover that light search. I can ask ESC supervisor exactly how we do it.
I just want to make sure that dude doesn't go to any academy whatsoever. And if he does, that we're somehow notified. I don't know if they can do that. If so, can we? Please? Okay.
Yeah.
So just no alcohol, no drugs, no new cases, and that's it. We'll see what happens. I'll obviously pop up on tomorrow's docket. And so just, we'll see. Okay. All right. Thanks.
Thanks, Judge. Maybe.
Yes, ma'am.
Council will reset.
Background noise. Where he starts again. Now, that's an interesting closed caption. Swallow them. All right. I don't know the context. Let's get to where he starts talking again.
I have Mr. Eduardo Garcia happy today. Mr. Garcia, Mr. Garcia is on probation out of your court. I think it's about 18 months for a DWI, and he picked up a new case for assault on the security guard. Been up one of the felony courts. And that case is still going on because he really wasn't a security guard, and there's a lot of issues on that case. It wasn't a security guard, he was just a bouncer, and the facts are debatable. So, but that case is still going on. And what I want to do here is we've already chewed him out and admonished him because he was the one that went to work out of town in Beaumont or wherever he went. Anyway, so he's been doing good. He's scared to death. He wants to stay on probation. I think he's better be left on probation than thrown into slamming. I mean, probation is good. Probation is.
This is an attorney who's not happy with this judge. Usually that doesn't end up well.
Rehabilitated and whatnot. He did get in trouble.
But he's got a bond violation.
The bond violation I saw, If I read what the bond violation is, that he's supposed to be stopping at a gas station on the way back from Beaumont. I mean,
He's not supposed to.
we're gonna go to the rules and we gotta stop.
Well, then you prepare before you go, you know?
It's
Like you can do all the, how am I supposed to know what he's doing? But, you know, when we told him, we said, you go straight to work, straight home. And I admonished him over and over, don't deviate. You're not allowed to go to Burger King. You're not allowed to go to Exxon. You're not allowed to do this. You go straight to work, straight to home. We give you a curfew. And here we are. Yet,
a gas station, but it's not like he stopped at a bar, a cantina, and stopped at a gas station on the way back from work. His job was over that day. He's coming back to Houston. He finished that job.
I know that you don't think it's a big deal,
Not really.
you know,
Station.
but conditions are there for a reason. And I didn't want him to even be out at all.
We had to drive back to Houston. Yes, his job was over.
What I'm trying to tell you is I didn't want him to be out in the middle of the night at all. And I relented because you guys asked, you say, hey, he's got to work, yada, yada, this, that. And I said, okay, but the condition is you go straight to work, straight home. Okay, we're going to do that. And here we are.
He stopped at a gas station. It's not like from his job site back to Houston. It's not like it's between. It's
Then take a piss before you leave. I've told you time and again.
Our bodies don't work that way. When our body tells us we gotta take a piss, we gotta take a piss. I don't just take a piss, you know, every once an hour.
Mr. Reyes,
Yes, sir.
how do we know he's taking a piss? How do I know he's not doing something else?
I don't know if he has a breathalyzer or what he has, but I'm sure that breathalyzer.
It looks like the last time we came before, we gave him a scram device, but it's been monitored by these problems.
By the way, just good morning. Good morning.
Is that no violations on the staff device?
Did you still report to some others? Yes. She said he's still reporting to probation is not good.
I don't know what I'm going to do with him, Mr. Reyes. I don't know.
Could we do this, Judge? Could we reset it and see how the case in the felony court goes? Because I'm pretty optimistic about that, but I don't know what's going to happen. But I know that. See what happens in the felony.
In the interim, he still gets to violate conditions, though.
No, absolutely not. I just asked him if he's been reporting to probation. He's still reporting to probation. I don't know if he has a new job.
Come up.
I don't know if he has a new job.
You don't know if he has a new job?
Yes.
What part of you are not allowed to stop at any other place did you not understand?
Your Honor, I was in the one that they were coming back, the job was done. So the guy wanted to stop at the restaurant for him, and he's like, I have to take it.
Oh, now he blames.
You can see for me in the juror box. I don't know, Mr. Reyes. Let me talk to him real quick. Come on. What's the last name?
Kasha.
Casher. Oh, Casher. Okay. What are we doing with Mr. Casher?
You know, the state of Argentina, it pays a restitution to those states.
We have a restitution dismissed. It was involved for a while. We have
Sure.
restitution information.
How much is it?
I believe $1,000. There's a bill in the portal that's available for defense. So.
Okay, so how long is it going to take to get, or do you want, is that what you want to do?
Yes, sir.
Okay, how long is it going to take you to get the $1,000? It's 300 days. I'll give you some time, but I mean, let's do this. I'm going to set it for trial because I'm not going to wait in hopes that he gets it done. He either gets it done and we'll give him 3 weeks. Either, you know what, we'll do 30 days, but I'm setting it for trial. If he doesn't have it done, he'll be put to trial. Okay, so exactly 30 days today. That'll be April 28th. So on Casher, if you don't mind setting for jury trial
Yes.
on the 28th. Okay, if he doesn't have it done by then he'll be put to trial. Okay, okay, thanks. Get ready. Counsel, hey, morning.
Judge Fleischer is not happy. Now, this is probably a case where he has repeatedly warned this person, if you want to be out on bond, this is what you need to do. Told him, do not stop. You go to work, you haul your ass back, you do not stop on the way. And now he's there. Well, my driver said he had to. Well, tell your driver, Judge Fleischer will put me in jail if you stop here. But permitted to buy gas can be done in different ways. I'm not sure. But to Judge Fleischer's, probably before he was back in court, was done with it, but gave him a last chance. So I do not know the facts of this case, why he is so adamant. But something must have happened in the prior hearing that this is the situation.
Okay. Just the last name.
All, H-A-L.
Okay, or do you want to give me the?
I got the cause number.
Okay, what is it?
Cause number is 261-0662. Enjoy you have the bill laws in here until PSR when you need it.
Okay, come up, Ms. Hall.
Yeah. And the first DWS from like 8 years ago, she successfully completed probation. This is the DWS second.
Sure.
Okay. So just.
Hello.
Ms. Hall, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you can afford one, one will be appointed to you. Okay.
On February 12th, 2026, in Harris County, Texas, officer was dispatched to a vehicle crash located on Lacey Road. Officer witness stated that they observed the vehicle crash into a fire hydrant at speed limit signs. The witness stated he attempted to check on the driver, who was identified as defendant to be, the witness observed the defendant to be in the driver's seat of the vehicle.
Okay.
Witness observed, sorry, Your Honor. Witness stated he observed the defendant attempt to drive away from the scene, but was unsuccessful due to the vehicle being disabled. Officer encountered the defendant and noticed blurred speech, glossy eyes, and odor of alcoholic beverage from defendant's breath. Defendant performed standard field sobriety test. Results were 6 out of 6 HGN, 7 out of 8 walking turn, and 4 out of 4 one-leg stand.
Unless it's regulated by law, do not do the impairment tests. Do not do them unless they are mandated by law. Because if the cop says you failed, you have failed regardless. Get yourself into precinct, blow there, give a blood sample if have to, but do, and this is, I've been listening to Larry, DUI guy, do not ever consent to these impairment tests, not ever.
Officer found an open container of tequila in the center console of the vehicle. The IC was read and defendant refused to provide a sample of blood or breath. A blood warrant was signed and blood was drawn.
Yeah, ta-da!
Are you alleging that she's consuming while drinking?
There was an open container in the vehicle, Your Honor, and it was 3 quarters full.
Okay.
And Judge, this is a juvenile because she was taken to the hospital, and the hospital basically you let the police take her into custody that night.
How high is the blood? Let's see.
And Your Honor, we do have blood results back. Result from 0.301.
301. Oof.
So even though they got them to a hospital, which everything that should have taken about half an hour to an hour, still blood work 301. Yeah, that's slightly above the limit.
Holy moly. Ma'am, I'm going to find that there's probable cause to go forward with your case. Does she have a license to drive?
I'm running the license right now, Your Honor.
As a condition of your bond, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. If I catch you driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. No more PR bonds. This is not a revolving door. I don't care who you are. I don't care how old you are. I don't care what color you are. You violate conditions. I only have one place for you. Do you understand? You will also get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You do? Do you understand? Don't use alcohol at all. Don't use anything that has alcohol in it. I don't care what the excuse is. Cakes, candies, foods, gums, energy drinks, tequila, lollipops, hair dyes. I've heard it all. It doesn't matter. Do you understand?
Her license is eligible, Your Honor.
Okay, you're also not allowed to drive unless you have valid liability insurance in your name. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with them and they'll tell you if and when you have to come back to court. Do you understand these conditions? Okay, so for now, we'll have you sign a reset. You'll get with Veronica for your bond conditions, and after that, you'll be free to go.
Is it a PR bond this morning?
Oh, no, it's a DWS second. So what do you think about bond? What's great state of Texas? Do you have a recommendation?
2,000, Your Honor.
Judge, we would request a PR bond was due to the age of the last case.
I'll set the bond at 2,000 and then I'll release her with you guys. And then just don't use alcohol. Do you understand? Or illegal drugs? Okay. All right. Got it.
Thank you so much.
Okay. Thanks, guys. Please. Hey, Veronica.
First.
Hey. Wait, I don't know. Sebastian, I'm going to split the puppy. So I'll set it at 1,000 for you. Okay. Yeah. Hey. Hi, Frank. What's up, man? It's just the last name. Okay.
He is in the jury box or bond.
Yeah.
Now late.
Well, he left.
2 times. Yes.
When did he come back?
Now.
So what should we do?
I asked him if he needed to extend this.
No, I'm debating whether to put him in jail, not give him a reward, Frank. I'm not.
This is his first bond violation.
No, but two different instances where he's just flaunting and just doing whatever the hell he wants to do. Mr. Barrera, come up. Does he speak English? How much do you want to go to jail, Mr. Barrera? You're begging for it. If you ever violate again, it's absolutely no tolerance going forward. You violate again, then it's not going to go well. Do you understand me? Last chance. We'll continue supervision as long as there's no contact with complaining witness, is there?
Correct. No contact.
Okay. Got it. Okay. All right. We'll continue.
Appreciate that.
Last time, Frank.
Yes, sir.
Hi.
Good morning. Thank
Good morning. Datus. Yes. Ms. Davis, you're charged with how many cases she have?
Plan to dismiss and resist.
Resisting? Okay. So you're charged with a total of 3 cases. You're charged with resisting arrest, theft, and terroristic threat. You have worked out an agreement where they're offering you 12 days with credit for 10 on the terroristic threat, 3 days with credit for 8 on the theft case. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept these will reflect as convictions on your record. They will be there for the rest of your life. You understand? Is this what you want to do?
Yes,
How do you plead to both offenses? I'm going to find you guilty. Follow the respective agreements. Understand that the theft case is an enhanceable offense. If you continue to pick them up, at some point they're going to hit you with a felony offense and you'll be looking at years instead of days. Understand? Good luck, man.
Thank you.
Thanks. Yes, ma'am. Hey.
Good morning, Judge.
Hey, bud.
You got Mr. Rafael Peña.
Is it Pena?
All right, before we listen to that, I see here we have a new judge to look at. This is Judge John Stevens, I think out of Beaumont, Texas. Let's see what he is all about. I've never watched this judge, so this will be a new experience on this channel.
And number 3, for assault, family assault. Then that's never a good thing. Number next is that there were 5 counts now of violations. Now there's 8. You got picked up 3 more. It states failing to work faithfully at suitable employment. That's one that we could take up later if necessary. But providing a urine sample in December that showed cocaine in your system, that's impermissible. And number 3, failing to attend batterers intervention prevention program. You're charged with assault, family violence, and that's the heart of the issue. And if you don't do that, you're not fixing the problem.
Beaumont. You guys can't pronounce French spellings. That clearly says Beaumont if you have the French spelling, but no, Beaumont. It's like Detroit. If we actually pronounced it as it was spelled, it's Detroit.
But anyway, you gotta fix that.
Sorry.
We'll get to call somebody.
No, it's not. I proceeded to turn on today. Messed up.
Okay. Are we ready? Is that going to happen again, or is Mike Laird's falsetto voice going to come out again like that?
Okay, this judge is a hard hitter. Okay, interesting.
Anyway, you're looking at 10 years up to 10 years in prison. And This in the first set of wrongdoing. We had 5 rounds committing an offensive criminal mischief.
Usually we just come back.
Being in another county without permission, failing to enter and successfully complete the batterer's intervention in the first place, in the first 5. And then now it's repeated. Anyway, what are you going to do? I can make them. No, it's.
Oh, east of Houston. Then I probably drove by there 2 years ago. 2 years ago, I did a south to north road trip in the United States. I started in Houston. I went to New Orleans, then up to Atlanta, then up to Chattanooga, Indianapolis, and then up to Detroit. So if it's east of Houston, I probably passed through it, went through it. Now, Houston is interesting because I spent the weekend there, and then I drove east towards New Orleans. And for the first 4 hours, I was still in Houston. and then I got myself to a Buc-ee's, and then onwards towards New Orleans. So that's 2 years ago. 2024. Oklahoma pronounces Miami correctly, but Florida doesn't. We mispronounce the Prague. Yeah.
We're not referring to anybody. We tell me.
We could interpolate your honor.
Is that what he wants to do?
We could give it up there for some chickens, perhaps.
But we gotta number one, you gotta fix. You gotta fix these things, because I can't let you stay out if you're going to admit again to
You're the freaking problem.
No, failing to attend. I'm sorry. That had to be done. You put you on my God, you put you on probation 4.5 years ago. Is that right? And you haven't done this? Is that right? I mean, okay. No, that's not excusable. All right. We're going to go through this?
Yes, sir.
All right. Then 20-34292 is called viewer Floyd Brooks. And this is the state of Texas versus Floyd Brooks. There is a first amended motion to revoke probation that's been filed as of March 2nd, 2026. Does the defendant waive any additional time he may have under law? He has a reasonable amount of time to prepare for this. Can we go and proceed by summary?
He does, wait, no, Your Honor.
All right, raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion states that on August 17th, 2021, in this court, you were sentenced to 10 years in prison. That was suspended. You were placed on regular probation. You were convicted and placed on regular probation for 10 years for the 3rd-degree felony of assault and violence. And it goes on that this indictment that you pleaded guilty to and were convicted of goes on to state that you had previously been convicted of a family violence assault before you picked up this other part of the allegation in the indictment. So that was the second offense of assault on a family member. And is all of that true, that you were convicted that day with a 3rd-degree felony? Correct? Oh, yeah, speak out.
Yes, sir.
All right.
I would assume it's going to be prison. He's not
He had
out of
earlier
prison.
entered pleas of true to allegations 3 and 4, being in another county and failing to enter and successfully complete the battering intervention program. He entered pleas of true to that back in August of last year, over half a year ago. And what the court did was, what I thought was a wise choice, which apparently wasn't, was to continue you on your probation. All of them. Allegation 6 now in this first amended states. I'm gonna pass that one. 7 states you provided a urine sample on or about December 10th, 2025, which showed the presence of cocaine in your system. Is that true or untrue? Yes. True. And 8, you failed to attend. Once again, this is the second notice. You failed to attend the Batterers Intervention Prevention Program, BIPP is what it's referred to as directed by the court, which is inherently important in this crime that you were convicted of. And that was a violation of a special amendment to your probation filed on August 6th of last year, after we went through the first hearing where you admitted not doing it. So did you fail to attend as required the Batterers Intervention Program?
True.
True. Are you pleading true to allegations 6 and 8 of this first amended motion to revoke probation?
Yes, sir. 7 and 8. You skipped 6.
I'm sorry, 7 and 8. Are you pleading true to those allegations voluntarily and because they are true as they are alleged? That's yes or no?
Yes.
Yes. Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation by preponderance of the evidence or greater? Your probation can now be revoked. You can be sentenced to no less than 2, no more than 10 years confinement in prison. Understanding and knowing that, do you insist on pleading true nonetheless? True. I find you pleading true voluntarily. You understand and appreciate the consequences of pleading truth. Let me see what percentage report would be tough. From probation, if I'd like to hear from you first, if you would be so kind. What happened that you are aware of? I mean, we called your hand on it in August about attending, how important it was for the BIP program to be followed. Why didn't you?
I do the bill. Then talk about the program I'm in now.
Yes.
You
admitted, no, wait, you submitted that you failed to attend as directed by the court. And what did he fail to do from program?
So some of the days he felt it's a weekly Zoom meeting and he failed to go weekly. And he's always like met the last progress record I got was back in February. So he only attended twice in February. I haven't got a progress report yet. Yes, it's weekly.
I do it every, but it's $25. I have 25. Since then, I've been going every week.
Well, since when?
Every week.
But she says you haven't.
Yeah, I've been going every week.
Well, has he attended or not?
No.
Every week.
I don't know about March, but February.
No. Since August of last year when we made a big deal.
He got in the because he was in Harris County custody until I think October. Then when he got out, he enrolled in the program. And
that's
December.
That doesn't do it for me. You can enroll all day long. You got to go through it and complete the program as directed.
Right. I told you I can do the first week.
He's supposed to do it weekly.
Yes.
Since August, how many weeks has he failed to attend?
It's 15 sessions, but I don't know how many he has actually attended.
Well, how did we file this if we don't know whether he attended or not?
There wasn't a date. I know this going to be an allocation.
He actually enrolled in the BIP program in November the 6th, on November the 6th, 2025. And he didn't get started until December. And from December, he didn't attend no sessions.
Let me start one problem at a time. Why? I thought I ordered that in August.
He was in custody in Harris County.
Until
October 8th.
That case ended up.
Is that right?
Dismissed. That's why we haven't gotten, that case ended up getting dismissed. We don't have a new allegation on that, so.
But back to the BIP, which is what we're here, what you're on probation for is BIP type of problems. The family assaults. You're supposed to be the leader of the family unit, not the record disabler of the family unit.
Dates he attended, Judge.
That's different. They figure $25 per session.
Failure is not an option. I don't care if you're selling pencils out on the corner, you got to go to the program. This is it's the essence of the program, of what you're charged with. Go ahead.
I've been going every Tuesday. I don't miss a Tuesday.
It's $25.
$25. I've been paying it since I got a job on.
Got good.
Yeah.
We also, like, I have one report from January 2026.
Credited on this.
Where he was attending, but he logged out early, and he doesn't get credit if he logs out early with no explanation.
Yeah. If you log out early and don't explain why, it's worth shit. Yeah. Oh.
Can I speak?
Hold on, let me read this. Okay.
You had one prior to that that was having internet connection issues, so they excused that absence.
Dates attended in December, none. There were at least 4 weeks. And you did not attend any sessions in December. You attended in January 6th, the 20th, 27th. And in February 3rd, February 24th. I mean, we got some gaps here. So
just to be forthright with the court, on December 30th, he reported he had to work, didn't make it, but there was an excused absence because of connection issues. And there's one that he appeared in December that he logged out early during the session so that he didn't get credit for it. So,
but dates attended in December, none.
Yes, he didn't get credit for anything.
Okay. And in January.
So he went there once in December and logged out early. Yeah, that's 0.
January 3 out of the 4 weeks. February 2 out of the 4 weeks. Unexcused absence on 12th. Then 1/13/26 a no-show. And then let's see, we had connection issues on December 12th, December 16th. On December 23rd, you logged out early with no explanation, no credit was awarded. On February 10th, you said you reported you weren't feeling well. And on February 17th, you were having connection issues.
Sure.
So.
Yeah, not buying it.
It's
I'm
not
having
fun.
one pickled herring, by the way.
It appears he's reporting it compliant.
That's not what this says.
We'll keep his probation officer.
He attended every day, never completed a full day, and connection issues, and no report, and yeah, that's failing.
This is the 4th violation he's admitted to. And one of these is a crime, cocaine in your system. And then a second allegation of not attending the program as required. You pleaded true to that earlier in another motion to revoke probation. So what we do up here is we set a standard. What's good for one is good for everybody. That's fair. We're trying to do fairness. How many intentional violations do you get before it's revoked? And everybody's going to listen because The next person that's going to come up on a motion to revoke is going to go, I'd like the Floyd Brooks rule, please. I'd like to violate 4 times, but stay on probation because you did it to him. Are you going to be fair, Judge, or not? What do I say to that? Oh, yeah, really, the cocaine? Where did you get the cocaine from?
From friend.
Well, who? See, you're not even you aren't going to give up your source. And that's the way it is. That's the way it is. No, that's of course. You think I don't see this after 45 years in this business?
Oh, well.
Come on. No, I'm not going to beg. You promised that you would follow the rules when we placed you on probation. This is the 3rd time you've been up here. Originally, the first motion and now the second. How many chances do you get? Everybody's going to watch and go, I want the chances. I want to be able to foul up 3 separate times, knowing I made a promise not to do it at the first place. You're running out of chances with me. What do y'all say?
Your Honor, I would just, if I might, be
How much time?
require the probation officer to be willing to work with him, what she thinks of the future.
I thought they were willing to work with him when we placed him on probation 5 years ago.
Well,
4.5 years ago. It's his problem. Now we've had to deal with it. And this is way too many times for crimes, for drugs, for not taking care of the whole source of the problem, the battering issues. You made bad choices. You don't even attend to that regularly.
Your Honor, if I might, I think that the ultimate goal of probation would be to rehabilitate someone and be able to restore them to society in a condition where they're able to participate.
Yeah, how's that going? How's that going, Counselor? How is that working? If he keeps returning to court?
I appreciate full legal law-abiding citizen productively. And I know that
Wait, what's law-abiding about buying cocaine? or purchasing drugs. Cocaine, it's a second-degree felony.
It's a continuing struggle with Mr. Brooks, but obviously there may be some positive things too that he's made progress with that would militate in favor of at least giving one more opportunity to do this probation. He has indicated that he's employed now. That's a huge part of probation. And he doesn't appear to be
This is his third opportunity. He was placed on probation the first time that we had a motion to revoke probation that I did it again. And then here we are.
Well, it seems to be reporting is required. Your Honor is working. That's probably, I would say, maybe half of what he needs to do. The other half, he's
committing crimes.
I don't have an explanation or excuse.
I know. You're in a hard spot. We set a standard up here. The victim in this case, do you still?
No,
you have no contact with that person?
I'm not doing that for now.
Sir?
I'm trying to go.
He's asking about contact.
The person who was the victim in the first place, you're not still married to that person or?
No.
Okay. Well, sometimes that happens and that's a problem because I want a family unit. And sometimes people make mistakes and we can work with keeping them together if that's in the best interest of everybody and we're sure that a problem's not going to happen. But that's not an issue here. I don't like breaking up families, but these are serious. The family unit was an important part of of America.
If the court's inclined for something lower and applicable statutory name.
Since he's not been to prison before, we'd recommend 5 years.
What we're saying. What do you say? You have a chance to be heard. You have 180 days credit. That's a half a year, but
yeah,
the state's asking for 5 years.
What do you have to say?
It's crime of violence. I mean, people don't find that amusing.
I need more plans to be out in this world. I can work. I'm gonna try and might get in no more trouble.
You made that.
No more drugs.
Probably
We'll know. We'll play everything. Please. I'll be well. I'm gonna do my classes on top of it. So this won't work.
How many times?
What's it?
That's fine. You made a deal with me when we put you on probation. I've received a copy of this order you signed, that you signed. I agree to follow all conditions imposed, and I know this probation can be revoked for any violation. This is the second time since then you've been before me for violations. You broke your promise twice. These are important things. It's not just, you committed a crime, but the batter's prevention is important to fix the choice you made here on assaulting a family member. This person, the victim in the first place, was actually wild. What, your wife?
My girlfriend.
Yes.
Okay.
Why? Yeah, it's your girlfriend. We understand that. Why did you assault her?
That's the wrong way to show affection, for someone you care about. Fine. If nothing further, I'm going to find that there is sufficient evidence supporting this first amended motion to revoke probation to grant it by a preponderance of the evidence or greater, as allegations 7 and 8 have been proven true, based upon the defendant's voluntary and knowingly made plea of truth to those allegations. Thus, I find this first amended motion to revoke probation to be granted by preponderance of the evidence or greater. Your probation is hereby revoked, sir, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years.
Oh.
And
still went quite lenient. The prosecution asked for 5. He got 3, and he has 180 days credit. So 2.5 years. Because cocaine and other probation violations.
you will be given credit for time you have served in this. Do you understand what has happened today, sir? All right, that is all. Amanda Nolan.
Yes. All right, let's check back to Judge Fleischer.
If we have an alternate path for you now, do you want to describe it, if you don't mind, Tori?
So the Millville caseload will be reported twice a week. That's currently the probation officer in the work, the resource center, transportation seems to look at one. I'm gonna make sure you get those back and all that stuff. The vertical will also be an option for you. They're gonna control all the SOPs, tap on it, so you'll report to the probation to be those diseases.
We are bending over backwards to help you, Mr. Mobley, and I'm telling you now, as a sanction, if you pick up a new case, if you violate again, we are going to do YMAC, the boot camp, in custody for a minimum of 9 months. Do you understand? So the next time you start thinking and it appears to be some kind of shenanigan, and I don't care what it is, you may find yourself that you bought a ticket to WIMAX. You and only you hold the keys to that cell. And I don't care if your mother, your grandmother, Jesus is here, is crying for you. You violate again, you know what's going to happen. Do you understand? That'll be your third strike. Okay, let's do it. We'll see how it works out. Extend it for a year. Last chance. Okay. All right, Roger.
Thank you, Your Honor.
You got it, bud. Yes, sir.
Oh, by the way, yeah, I bought the 2 jackets. It will arrive here roughly in 2 weeks. So I bought this one and this one. So a velvet and palliate tuxedo. Because I got inspired. Now, if you want to help out, I would be very, 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 very appreciative of it, because the combined cost here is about $80, which in super chats is about 120, because YouTube needs their cuts. Or if you choose Buy Me a Coffee or PayPal, they only have a 3 to 5% cut. Because I had a couple of beers, and drunk Nick likes to buy sober Nick presents.
Sorry. All right. Good morning, Mr. Belloc.
Good morning, sir.
Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 6 days in jail with credit for the 25 days that you have done. You were giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, it's final. You can never take it off. It will go on your record. You understand? Are you sure? It means you plead guilty and it goes on your record. But did you understand what I just said? Right. If you run from the cops again, do you know what happens? But you need to know what happens if you pick up another evading arrest. What happens?
Oh, I can't hear. In fact, I can't hear. And I'm saying to friend, I cannot hear. Yeah, but I don't understand. I couldn't hear.
No, it's all right. Okay, Allie, hi. Thanks for being patient.
No, that's okay, Judge. I am approaching on Destiny Ward.
Okay.
She's up on the jury box in Fort 8 right now. I'm just gonna see if there's any way that we might keep her out of custody today.
No, we have 3 cases. Literally, she gets an assault dismissed in February. Now we have 2 new cases now.
I understand, Judge. So the only thing I will say is she's 17 years old right now. The state did just make contact with the CW in the terroristic threat case. The mother is okay with her coming home as long as there's no threatening, no harassing. This is kind of a crucial time for her right now. She is on track to graduate in May. However, tomorrow, Wednesday, and Thursday, she's got makeup hours that she sits in all day. And that is what is keeping her on track to graduate. So she's very concerned about going into custody. Even if we could have a delayed report-in date or something, if she could make
show me that you, because I'm not going to take anything from. So let's do this. Roll it to tomorrow, but I want proof.
Thank you.
Show me, and then we'll talk. But
Thank you.
She needs to understand that. I mean, they're allegedly, according to him, being, and she's on bond.
I understand, Judge, and I just.
Show me tomorrow. Let's talk.
That's fine, Judge. So if I come tomorrow with proof, she can go do her hours. If she does not send me proof, she needs to be here tomorrow.
Oh, no. I'm taking her in.
Okay.
I'm taking her in right now, and I want you to show me first, and then we'll talk about a game plan on how. And what we do on the outside. But I'm not taking her work. Not when we're on a over and over and over.
That's
She needs to know that we need
Are you gonna be here for a few hours if I am around to try and get approved today?
Sure.
Between her mom or son?
Yes.
Okay.
Yep.
Thank you.
Okay.
I'll work on it.
Thanks.
Judge Cockroach?
Yeah.
Run out of the Sanders. On the Sanders.
Okay. Are you ready?
Can I follow up?
Please.
Thank you. Stand.
Mr. Sanders, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 6 days in jail with credit for the 2 days that you've done. You give up a lot of rights by entering into this agreement. This will reflect as a conviction on your record. From now on, you'll be facing a minimum of 30 days in jail. You understand?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, there's no changing.
Right.
Is this what you want to do? How do you plead to the offense, sir? Guilty or not guilty? I'm going to find you guilty. Follow the agreement. Good luck to you, sir. Please do that. Thank you. Thanks. Yes, ma'am.
That over here, Sanders. I guess the comment is we got covers what if electric to the code before class.
Okay, Mr. Belloc, we're back. So what are we doing today? Is this what you want to do?
Yes, sir.
You're doing it freely.
Yes, sir. Yes, sir.
No one's forcing you to do it. What happens if you run from the cops again? Well, you're not going to be dead, but something bad. I mean,
And then the charge.
what's going to happen if you right years instead of days? Do you understand? Well, I don't know. I hope. So how do you plead to this offense? Guilty or not guilty? All right, I'm going to find you guilty, follow the agreement, sentence you to it. Good luck to you, sir.
Thank you, sir.
Okay, thanks. Are you ready? Are you,
Me?
yeah, are you ready?
Judge, we have an interpreter for verification purposes.
Oh, Emily, Emily, are you ready?
You have, the interpreter, if you need the defendant to testify about anything.
No, he's not testifying anymore.
Okay.
No, we're done. I mean, I'm letting him in now. He can listen, but he's not testifying.
You have the interpreter.
Okay. Hi.
Yes, sir.
Do you mind helping us out?
Was he supposed to interpret?
We wait information, Judge. I mean, this is.
I mean, it's just argument anyways, right? Okay. Yeah.
At this point,
Okay. Yeah, I think we're good.
Yes.
Thanks. Are you ready? You ready? Guys, we are going on the record. Do not talk or talk outside if you need to, please. Yeah, it's probably better, you guys, if you don't mind coming up here. Mr. Smith, are you with Emily?
I am
Today?
Good morning.
You're free to hang out. Come on up. It's up to you. Of
Thank you.
course.
Judge, just before we begin, I go through the case law and my notes. I know the court's busy. I'm not gonna keep it, it's not gonna be long, but it's not gonna be short. It's gonna be about 15, 12.
That's
15
okay.
minutes.
As much time as you need.
Just giving the
Right,
court-
just be reasonable. Don't take 45 minutes.
Absolutely, but just giving the court a heads up.
Yes, that's fine. And to just go kind of slow so that, Ramona, and then,
Yes.
obviously I will give you an opportunity to,
And we gave Ramona a list of our citations that we're gonna use, so we don't have to slow down, do everything for the sites.
all right, we are back on the record and cause number 2580504. A writ of habeas corpus that has been filed by Mr. Cedillo regarding Mr. Barrientos. When we last left, we had heard from Mr. Barrientos. We had heard from both counsel. We had heard from state. But Mr. Cedillo filed, I guess, a supplemental brief. And you had not had, Emily had not had a chance from the state to look at it. So we did a short recess to today so that you could digest it, make any last and final arguments. I'm going to leave the floor to you, Mr. Cedillo.
Thank you, Judge.
Please.
Like I said, I don't plan to be too long, but I'm going to do three things. I'm going to go over the case law and the writ law. I'm going to go over the facts that we got from the witness and the record and show how we believe we met our burden. And then I'm going to address the state's arguments. Those three things. First, Your Honor, this case is about a complete breakdown of my client's constitutional rights. It's about the denial of his right to counsel. And the state is essentially going to tell you from their arguments, from their brief, they're essentially going to tell you that you should overlook that breakdown, that denial of my client's rights because of the passage of time and because there's a box checked on some old plea paperwork. That's essentially what the argument is going to boil down to. So let's start with in reverse. How did we get here? At the last setting, Your Honor made the point that we wouldn't be here if just a couple of months ago, my client hadn't come back from Mexico, the federal government hadn't used an old felony against him.
Now this is interesting. If what this attorney is saying, and I've seen Judge Fleischer before going absolutely ballistic on the prosecution. So this better be correct.
Detained him. Your Honor pointed out that he never really complained about this until the situation confronted him. That's exactly right, Judge. And I wanted to allay any concerns the court had about the passage of time by citing or bringing up to the court ex parte Harrington. In that case, the Court of Criminal Appeals laid out the standard for habeas relief. They talked about what custody means. And they said someone is in custody for habeas purposes if they're suffering collateral consequences. If they're suffering collateral consequences, then habeas relief applies. The inquiry is not about how long it took to get relief. There's other defenses which the state has raised about time, which we'll get to. But for the purpose of habeas, the ex parte Harrington boils down to this rule that I'd like the court to remember. If the conviction is good enough to be causing the client injury, it's good enough for the court to challenge, and it's good enough for the court to fix. It's certainly doing my client injury. In 1986, he took that plea uncounseled, and we argued without a valid waiver. When he took that plea, a few years later, that enhanced another DWI for DWI second, and most importantly, in 2006, it was used to raise a DWI to a felony. He would not be a felon if not in part for what happened in 1986. And then, of course, not only did the state of Texas use that against him, the federal government used that 20-year-old conviction against him a few months ago when he was coming back from Mexico. As a long-term resident, he's allowed to come back and forth. And when he was coming back, his felony status, which he was a felon because of partly what happened here,
Okay. This is where Dali had issues with his stream. Come on. Come on. I want to hear this. Come on.
For that, the judge did giving him a reset to get a
All right.
Giving him a reset to get a lawyer. Instead of doing any of that, the judge did the opposite and said, you don't need a lawyer. Just take the plea and sign the paperwork. It's a fine only. So what Oscar was describing was a complete breakdown of his rights. Instead of a safeguarding of rights, it was absolutely nothing. It was a denial. Now, the state doesn't really have anything to impeach my client's memory or credibility. They pointed out a few things that he didn't remember, like leaving a fingerprint, or like whether he talked to the DA, but none of those things really go to the core of his testimony about what the judge said to him and what the judge didn't say to him. And that part was unimpeached, and that's the crucial part of his testimony. Now, the only thing the state is going to point you to the record is the checkbox. But for that, Judge, I remind you about what the Supreme Court says in two very important cases about waivers of fundamental rights. In Johnson v. Zerps, the Supreme Court said courts indulge every reasonable presumption against waiver of fundamental constitutional rights. You have to be very skeptical when a fundamental right, like the right to counsel, is denied. And then in 1962, they clarified the rule in Carney v. Cochran. Waiver cannot be presumed from a silent record. I quote directly, presuming.
Oh, they are going way back in time for fundamental precedents. He better be correct here.
Waiver of counsel from a silent record is impermissible. To sustain a claim that counsel was waived, the record must show, or there must be an allegation of evidence, that the accused was offered counsel but intelligently and understandingly rejected the offer. That's from Carney. In this case, Judge, a simple checkbox is essentially a silent record. It's not a colloquy. It's not a transcript. It's not a written, the state doesn't have any written plea admonition saying this is what the judge said. There's certainly nothing signed by my client acknowledging the rights that he heard and that he was giving those rights up. And more importantly, the checkbox doesn't defeat my client's testimony that he had a quick discussion with the judge, and it was all about that he didn't need a lawyer, and it was all about he should take the plea. So under that, Judge, I think from the record, which includes my client's testimony, we have a clear violation. So the state made a couple of arguments about what happened after that plea that I think I want to talk about. First off, the state said that, well, there were some future pleas. There was a plea in 1989. There was a plea in 2006. But the future pleas are not retroactive constitutional waivers. If my client didn't know in 1986 what he was giving up, there's been no testimony, and he took an oath and he was subject to cross-examination. The state didn't show that he had suddenly gained some sophistication, no offense to my client, or that he went to law school and suddenly knew his rights. He didn't know his rights in 86. He didn't know them down the line. And to say that maybe some other lawyers down the line also didn't look into that prior conviction does not relieve my client of the right or show that he has some kind of waiver. Just because other folks dropped the ball doesn't mean that he suddenly knew or should have known about his right to counsel back in 86. But more importantly, Judge, I'm going to quote the Supreme Court again, because they also took up a case that essentially encapsulates the state's argument. The state's trying to tell you, my client had other reasons down the line, but he kind of ratified. He pled true a few times later, so it kind of ratified that first waiver. The state in Burgett v. Texas had a case. It was exactly similar. A client went to trial without counsel. He was convicted. And then later on, he had counsel. He took a plea. And then that plea went all the way to the Supreme Court. And the Supreme Court had a situation in front of them where they could have said, like the state is urging you, they could have said, plea number 2 with counsel makes plea number 1 okay. It's a waiver. It's a ratification. That's what the state was essentially arguing without arguing that. But that's not what the Supreme Court said about that case. The Supreme Court said, to permit a conviction obtained in violation of Gideon to be used either to support guilt or enhance punishment for another offense would erode the principle of that case and allow an unconstitutional procedure to injure the defendant twice. They vacated the second plea because of the uncounseled first conviction, Judge. They did not find a waiver in that case. Your Honor should not find or imply a waiver in this case because my client had taken other pleas years down the road. The other time argument the state is making is the defense of latches. That is a defense that's allowable to them in the state of Texas, Judge, but it's not simply a defense that happens because this is an old case. Ex parte Smith and ex parte Perez lay out the framework for when latches apply, and you have to look at the length of the delay. You have to look at the reason for the delay, who's caused that delay and relief being requested, and the state has to show prejudice. And importantly, in those cases, Judge, time alone is not prejudice de facto. The state has to explain to the habeas court what they're missing, how they're prejudiced. They have to show material prejudice. So let's look at the factors. First of all, the length of the delay. The length of the delay and the reason for the delay kind of tie together. My client was unsophisticated. He was not aware of his rights in 86. The judge told him he didn't need a lawyer. That's probably what he believed for decades. He probably didn't know that he had this right that he could go back and challenge. When the consequences came to him and he had counsel that understood the severity of an uncounseled plea, he did challenge those rights. He challenged them. The habeas is the vehicle for him to do so. So your honor should not hold against him that the consequences took this long to germinate. You know, he was not aware that he was injured until those consequences came about. Secondly, the reason for the delay. This is not a case, Judge, where my client was aware he had a claim and then sat back on his rights and then said, you know what, I'm going to wait until the records go away. I'm going to wait until the witnesses don't remember. Then I'm going to jump in and request my rights. That's when you can weigh against the client like that. But my client didn't know. He didn't know that. The consequences were raised by the state. The state chose the timing of when to use the allegations against him in 2006. And the federal government, the state, chose to use the allegations against him in a few months ago. So the state was in charge of when the consequences fell on my client's head, not my client. So that shouldn't be used against him. Shouldn't be held against him. And the last prong is prejudice. And I've got two things to say about prejudice. One is the state has to explain to you, Judge, and I urge them to, how they actually are prejudiced by the passage of time. If the state can say, well, there were plea papers, you know, we know that these were destroyed, we should have fuller plea paperwork here, then maybe your honor might say, okay, well, that would have helped your case. We don't know what was destroyed. We don't know if any paperwork was destroyed. My client says he remembers filling out paperwork about a time about paying off the fine later. Maybe that's the paperwork that was missing. So we don't even know what records are missing that would have helped the state. So I think the state is asking you to presume because records might have been destroyed, it would have helped them. That's not what the standard is under Ex parte Smith and Ex parte Perez. But what we do know about the prejudice to the state is that they were in charge of the retention policy. We know that the state chose what records to destroy. The state chose when to destroy those records, and the state chose to bring up a case with this thin record against my client. So all the consequences about we don't have enough records, you know, we have a retention policy, that should go against the state judge, not my client. He was in charge of those things. But he asked for an expunction, and then now is coming and, you know, asking for the case to be vacated somehow. That's out of his ability, Judge. Also, I'm just going to take the argument to the extreme about prejudice. If you allow the state to say we destroyed files, and so you can't review this habeas case properly. The state said they had a 5-year retention policy. Theoretically, the state could have a 3-month retention or a 6-month retention policy, and they could always defeat habeas review if they destroyed their files quickly and say, well, it's not our fault, you didn't complain fast enough. You know, there's always going to be sort of a moving the goalpost situation. My client, and going back to Ex parte Harrington, they chose to use this case. They chose to defend this record. They wouldn't be here defending this record if they hadn't used this case with these destroyed records against my client. So that doesn't weigh against my client, it weighs against the state. So because all those factors do not weigh against my client, Judge, laches is not the defense that you all should rely on. And after everything, laches is about fairness. The fairness has to be put into balance, Judge. It would not be fair to allow my client's denial of a very fundamental right, a right that under Gideon v. Wainwright in a courtroom makes all other rights possible, as the Supreme Court said. It would not be fair to deny him of that right because the state chose to lay behind the law and use an old conviction or because of their retention policy. It's not fair. So the only last thing I want to raise, Judge, is the time argument wise, the last thing I want to talk about is finality. I think the state hasn't raised it directly, though in our last setting, they said, well, if Your Honor vacates the conviction, we don't have any records, we're probably going to have to dismiss this case. And I think the court might be concerned just with the age of the case and with overturning a very old conviction. In all the habeas cases, Judge, finality is very important. It's a very important policy goal. But if we're talking about public policy, there's another public policy that I think is just as important as finality of convictions and, you know, finality of procedure. And that is the public policy in a court that fixes its mistakes, the public policy in a court that doesn't allow injustice to stand. Everyone who's in this courtroom knows, Judge, that you hold defendants to the consequences of their action. If you look at this case, look at this record, look at my client's testimony, and you strike this conviction down because of what happened, everybody in this court will also know that that Your Honor holds the bench to those same high standards. And that's an important policy goal as well. So I'm not asking the court to do anything extraordinary, Judge. The cases I've laid out point the road for relief. We have to meet the Hades requirements. We have to show proof of injury and violation. Your Honor has to not presume waiver from a thin or a silent record. We've done all that. At the end of the day, we have a client who was injured, his rights are respected, the conviction ought to be vacated, habeas relief is eligible, and because the Constitution wasn't followed in Court 5, 1986, Your Honor can fix that problem right now, today, by granting the writ, and we urge you to do so.
I don't know who this lawyer is, but I would hire him. This is an attorney that zealously fights for you. Okay.
Okay, off the record for a second. We're done. Are you guys waiting for anything?
Judge, council's filed some motions to withdraw, so I need to
Kobe?
know- No, Aircon
Oh,
Gardner.
well, no, Kobe, you're good. We're done.
So you're not gonna appoint on the two
Well,
motions?
no, we'll deal with that in a second. Just go. You don't have to, we're good. Ralph, let me finish up and then I'll take you up. Okay, are you ready? Okay. I just don't want you guys have to wait for us. That's it. Okay,
Let's see what the state says.
back on the record.
The state's position is very simple. They have the burden in a writ, and they have to prove that the waiver of counsel was invalid. The applicant refers to it as a thin record. However, we still have a record. And the record shows that the waiver of counsel was knowingly, intelligently, and voluntarily done. And that is all the evidence we have in this case regarding the waiver of counsel until the applicant testified last week. So what is the evidence we have now that he testified? He said the judge told him to sign papers and that it would be a fine. And that was about all he could recall about what the judge said. And he couldn't recall that he signed papers. Either he did not read them or he doesn't remember if he read them. I can't recall exactly, but regardless, we will never know what those papers said that he signed. They very well could have been waiver of counsel. And he was signing the papers saying that he agrees to waive counsel. But the applicant doesn't get to hold it against the state that records are no longer available. That cannot be a way that they prove there was a constitutional violation, because there's a retention policy that every other county in the state has as well.
Folks, in my personal opinion, the state has an obligation to preserve everything that's been said in court. I don't give a flaming fuck about if it's a house fire. I don't give a flaming fuck if it's a computer hack. State still has an obligation to preserve the record. And if they don't have the record, that should be counted towards the defendant.
So the fact that there is a thin record doesn't get to be held against the state, since it is their burden to prove that the waiver of counsel was invalid. If you overturn this conviction, the court will be agreeing that the waiver of counsel was invalid. And the evidence needed to prove that is a defendant testifying about what happened 39 years ago without any notes of what occurred, and just based off his memory saying, the judge told me to sign here, and so I did. That alone would mean that any defendant can come forward, and if the records have been destroyed, they can prove there was an invalid waiver.
Yeah, and they should, because if the state destroys records, it's on you, in my opinion.
Just based on recalling two sentences that a judge said to them. And so that's why the state believes they have not met their burden. Also, the testimony needs to be considered in light of the fact that he only recalled things that were helpful to him. He didn't recall the DA He didn't recall how he got the deal. In the judgment, it says that the enhancement was abandoned, and he doesn't recall how that happened. He doesn't recall the actual plea was 3 days. It was the time served plea, 3 days in jail, but he'd already served 3 days. And additionally, I understand that he's now bringing this up because he was deported. However, latches isn't about why you do or don't do something. It's as soon as you knew there was an error, why was it not brought to the attention of the court to fix the error? And the reason the 1989 case was brought up is because in 1989, he would have discovered that there was an error in 1986. Because it wasn't affecting him, I assume, is the reason he didn't bring it up or pursue it or try to fix what happened in 1986 once he learned in 1989 there was an error. That also discredits his testimony that he is now coming forward and somehow can recall some exact wording by the judge, but then can't recall anything else. There was also much of the 1989 case, he could not recall what had occurred or if he had talked to his attorney about how the 1986 case, he realizes he pled guilty and didn't know that he pled guilty and that he should have had an attorney, but he did not. The law just says that it's their burden to have clear and affirmative evidence that the waiver was not valid. So if the testimony by the defendant was clear and affirmative evidence that the waiver was not valid, then that would be a reason to overturn the case. Again, the state's position is that they have not shown their burden. They have not shown evidence that it clearly was not a valid waiver. And the latches argument is the same as I stated on Friday, 39 years, no explanation for why he couldn't have brought it sooner when he did know about it or could have known about it at the earlier stages. We are harmed in responding to the writ because we don't have any of the paperwork. We would also be harmed in retrying the case due to it being 39 years old. And for all those reasons, that's why the state asks that you deny relief in this writ.
Okay. You know, I strive to try to be fair to everybody. Let's think about this, right? The length of the delay, 39 years, reason, because it's not affecting, right? The prejudice to the state, there's nothing left. So what happens if we open, if we grant, you know? How's that fair? People waive attorneys all the time. Think about municipal court. All the time people waive attorneys and they just, let's just get it done over, you know? And I have to imagine in 86, I can't though. I can't speculate what possibly happened. I don't know. But nevertheless, I don't think it would be fair. I'm sorry, I have to deny it, right?
This disappoints me, I must say, because now you're holding it against the defendant that the state have destroyed the evidence. I don't think that's fair, because there's only one person in that courtroom that has rights, and that's the defendant. Judge Fleischer, I like you. I think you're fair. I think in this case, you're wrong.
Thank you, Judge.
Folks, we are almost 4 hours in. And it is roughly 2:30 a.m. where I am. And I had my beers. I do have a few items of pickled herring left. In the beginning of this stream, I showed you how to make hot mustard pickled herring. And I have a few items left here. So, with standard mustard, peri peri hot sauce, and pickled herring. And to wash it down, I have Aalborg horse schnapps. Folks, thank you. Thank you for showing up. Thank you for hitting the thumbs up. Thank you, folks, for you who are alone over Easter. I hope I brought you some easement to that. I hope I did. But you guys, a big thank you. And from me and Mr. Jingles, let's see if I can get him on screen here. Dun, dun, dun. Here. There you are. With a meat stick. Nom, 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 nom. Nom, 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 nom. Thank you. I will return tomorrow with some news about the Michigan hyperbaric chamber case and continue to read about the Delphi appeal. Again, thank you. You all have a good one. And remember, folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. From me, currently, the Chicken Pope. Have a good one. See you tomorrow. Bye-bye.
Sail the raven waves, brothers, axes high, shields strong. From distant lands we